Good morning, Your Honor, and then on behalf of the people, Your Honor, people with any potential conflict between this honorable court and the Office of Public Defender, while people don't believe such a conflict exists, that people make this waiver and avoidance of all doubt.
Thank you.
Good morning, Your Honor. Intern Malaika Fatima requesting to practice under MCR 8.120 under the supervision of the Deputy Chief Public Defender, Lauren Brown.
Permission to practice is granted.
Thank you, Your Honor. We do not believe there is any conflict between this honorable court and our office, and if any conflict is to arise, we waive that conflict so that this honorable court can hear our matters.
Thank you.
Thank you.
Court, for its part, also does not believe there's conflict other than Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the People versus Seth Pester.
Here, Richard McDuffie for the people. Good morning, Your Honor. Wendy Barnwell, C42505, on behalf of Mr. Priester, who's present on the Zoom.
Good morning, sir. Can you state your name, please?
Good morning, Seth Pester.
Thank you. All right, what are we doing?
I had an opportunity to discuss the status of discovery and potential scheduling with Ms. Barnwell and Ms. Constantino, who has the codependent in this matter. It looks like there's one additional piece of discovery that should be coming in the next week or two. We discussed dates, and we'd like, is it the 18th?
No, it wasn't in June, it was in July 18th.
Yeah. I believe you want to set this for an preliminary exam on July.
Discovery complete.
So as I mentioned, we have that one additional piece that should be coming in the next week or two. Ms. Constantino and I and Ms. Barnwell discussed potential scheduling regarding that, and so we agreed on July 18th as a preliminary exam date.
July 8th.
Or was it the 8th or the 15th? Whatever the latest date was.
It was the 8th and the 15th.
The 15th.
We selected 2 days.
Yes, apologies, the 15th.
So as not to be repeating this every week or so.
So as to do what?
Not to be in the same exact
What is the
position.
discovery that's outstanding?
There is an additional product of a search warrant return that they have received and are processing, and it should be ready within the next week or two.
Because I don't like setting these exams, and I guess, Ms. Constantino, you're on the line. Council's aware that if that doesn't come in, that's not going to be the basis for an adjournment.
Yes, Judge. I am on the line and I'm aware of that. Thank you.
Ms. Barnwell, you're aware of that?
Yes, Judge.
What dates were you talking about?
July 15th?
Yes, July 15th works for me.
We don't operate that way. You guys know that, right? I'll do it this time, but we don't operate that way. Preliminary examination in person will be set July 15th, 2025, 9 a.m. That is before Judge Moore. And we'll continue.
Thank you, Judge.
Well, it does call the case, People versus Mariah Thomas.
On behalf of Ms. Thomas. Ms. Thomas, can you please state your name for the record?
Mariah Thomas.
Thank you.
Donna, we're going to be asking for a brief adjournment to continue plea negotiations with prosecution.
Probable cause conference will be adjourned to June 26th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
June what?
Court does call the cases of the People versus Spencer Norton. 4 cases.
And is that on behalf of the people, Your Honor?
No. Project, says no comment.
Was he here?
It's no.
Jeff Pearlman? We check in with you. I'll pass the matters. Court calls cases in the case of the people versus Rafael De La Cruz.
Morning, Your Honor. James McWheel, Special Assistant Attorney General on behalf of the people.
Thank you.
Fatima Dadush on behalf of Mr. De La Cruz.
De La Cruz, can you state your name, please? See here.
I do not know what Mr. Devlin is here.
He did tell me he is on the Zoom.
Rafael De La Cruz? I don't have him.
Your Honor, please pass on this. I'm gonna give him a quick,
I have
Oh,
118
that's
cases.
not him.
Rafael De La Cruz?
I see his name on the screen up there.
That's Rafael Chavez.
Oh, Chavez, I'm sorry.
Morning,
Chavez. Good morning. What's your name?
Rafael de la Cruz.
There you go.
All right. You're not driving, are you?
No, I'm parking by the street.
Pardon?
I'm by the street.
Okay. All right. What are we doing?
Your Honor, there's an offer, the standard AG offer on this case, for a delayed sentence. I was talking to AG Williams about it and I let her know that Mr. De La Cruz is going to be taking that offer. I believe we have to waive the preliminary examination and do that in circuit court.
So he's waiving.
Yes, Your Honor.
Mr. De La Cruz, you're waiving your right to a preliminary examination?
Yes,
Do you understand that that's a proceeding where the people would have to show by probable cause that the
Yes.
offense alleged was committed and that you committed it?
yes, I understand.
Do you understand you'll not have that hearing and that you'll proceed to circuit court for further resolution?
Yes,
People also waive their right.
We do, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count. Mr. Dish.
I always forget what comes after. We stand mute and wait for the reading of the charges.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
2025, and 1:30 with Judge Fleischer.
August 4th, 2025, 1:30, Judge Hammoud.
Thank you, Your Honor.
Bond will continue. Thank you.
Thank you.
Court does call the case of the people versus Myron Bonds.
And I still like to bring on behalf of the people, Your Honor.
Geraldine Foster Tucker on behalf of Myron Barnes.
Myron Bonds. Thank you.
And Your Honor, we're just requesting an adjournment to review discovery and work towards a resolution.
You were just appointed on this matter. Probable cause conference will be adjourned June 26, 2025, 9 a.m.
That's we're gonna get right in.
Continue.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Richard Brunelli.
Alexander on behalf of the people, Your Honor.
Good morning, Your Honor. Edward Jukas on behalf of Richard Brunelli, who is approaching.
Richard Brunelli.
Thank you.
Your Honor, to my knowledge, discovery is complete. I'm asking for a preliminary examination.
Probably 24.
Yes.
People have their witnesses available June 24th.
We'll do our best, Your Honor.
Preliminary examination in person, June 24th, 2025, 9 a.m. That is before Judge Washington. Brown, continue.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Jason Burkett.
Number Douglas, the people.
Good morning, Your Honor. Christina Costantino appearing on behalf of Jason Burkett. And Your Honor, may I approach? Mr. Burkett, could you please state your name for the record?
Jason Matthew Burkett.
All right, I have before me a plea form that indicates that we're pleading to 2 counts. Well, is he pleading to the felony?
Your Honor, today he's, not the felony. Today he's pleading to, the misdemeanor, but we get on his other case, which is not going to be reported today, that on his other case, he's going to, plead on it.
The judge, he has a misdemeanor case that is scheduled for next Wednesday in the 15th District Court. This is a global resolution in which Mr. Burkett would be pleading in that file on Wednesday in the 15th. And he would,
Okay, so the only thing that he's pleading to today is the license plate title registration charge.
yes, Judge, that's correct.
That's correct. Thank you. The plea form indicates that he's going to do that, and he's also going to plead in a 15th District Court case to count 1, the breaking and entering a vehicle to steal property, 200 to 1,000, the 1-year offense. He'll plead to that case at another time. He's going to plead to this case, and then count 1 would be dismissed. That's the court's full understanding of the agreement. Is that correct? May I have him sworn?
Do you solemnly swear or affirm the testimony you're about to give will be the truth, no truth, and nothing but the truth, so help you God?
Yes, I do.
Go ahead and lower your hands, state your name, spell it out.
Jason Matthew Burkett.
All right. So it is this court's understanding that you are going to be pleading guilty to the charge of unlawful use of a license plate, title, or registration. That is a misdemeanor punishable by up to 90 days incarceration and or a $100 fine plus court costs. You understand that, sir?
Yes, Your Honor.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge
Yes.
Perry in the 15th District Court.
Yes, sir.
All right. Understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
All right. Did you sign an advice of rights form, sir?
No. Not that I do, unless it was a while ago.
Understand that because you're not having a trial, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes, I do, Your Honor.
You understand you're giving up your right to appeal of right.
I'm sorry?
You're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes.
of your own free will
Yes, sir.
and because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
All right. Counsel, pursuant to the new court rule, is counsel aware of any promises, threats, or inducements that have caused this plea that have not been disclosed to the court? Madam Clerk.
No, Your Honor.
All right. Sir, on the date of September 22nd, 2024, at the location 601 South Main Street, City of Ann Arbor, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Actually, I was inside the gas station whenever I came out. The police were there.
But you had been driving the motor
Yes,
vehicle?
yes, Your Honor.
And was there something wrong with either the license plate, title, or registration on that vehicle?
Yes. It wasn't correct plate. It wasn't the correct plate.
All right, so the correct plate or the plate that belonged on that vehicle was not on that vehicle?
Correct.
Is that correct?
Yes, Your Honor.
All right. So I do have to advise you, and I don't know that there's been that, there's not a sentencing recommendation in this case, but if there were one and the judge does not follow that, Judge Perry, you would not be entitled to withdraw your plea as a result thereof. Do you understand that, sir?
Yes, Your Honor.
I also have to advise you that if I accept your plea and you commit misconduct after this plea is accepted prior to the time of sentencing, you're not entitled to withdraw your plea unless allowed by the court for a good cause. You
Yes.
understand that, sir?
Yes, Your Honor.
All right, counsel, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count two, excuse me. Count one is dismissed. Pre-sentence investigation is ordered at 15th District Court probation. Sentencing in this matter will be
July 3rd, 2025, 10 a.m. Judge Perry.
July 3rd, 2025, 10 a.m., Judge Perry.
Thank you, Judge. And could I
Thank you.
respond briefly?
Yes.
Judge, my client has been in custody now for about 21 days. He did, as Your Honor knows, just enter a plea for a misdemeanor that carries a maximum of 90 days in county jail. Should he be released, he does have employment lined up. He was working at Petaway prior to his incarceration, and if he is released, he would be able to return to his employment there. He would be residing at the Delana Center, which obviously is very close in proximity to the 15th District Court. He has been staying at the Delana Center since last March. He is in the process of getting some more permanent housing set up, but obviously has had some difficulties doing so from the jail. He will be set up with community mental health upon release, and he has a peer recovery coach that he would be working with as well upon release. Given that, we would ask the court to consider a personal bond.
When is he got a PR on his other case?
He doesn't, Judge, but it's my understanding that Judge Perry indicated that if his bond was amended in our case, that she would amend his bond on this coming Wednesday to a personal bond. And his court date's this Wednesday, June 18th, before Judge Perry.
Or officers, they said they would check into the court system later on today. My other lawyer, Delphine.
What I'm going to do in this case, I guess technically I would deny it with this modification, or actually grant it, just do it this way. I'll continue his bond at this time. However, I will grant him a PR effective July 18, 2025.
Thank you, Your Honor.
Thank you, Judge. And I just want to make sure the court said June 18th, or did the court say July 18th?
If I said July, I meant June 18.
Okay, thank you very much.
All right. Here. Court does call the case of People versus Joe Kraut.
Alexander, on behalf of the people, Your Honor.
Christina Costantino appearing with and on behalf of Mr. Kraut. Mr. Kraut, can you please unmute your device and state your name for the court?
Joe Crow.
See him. Mr. Kraut, can you state your name, please? Try again. I can't hear him, but if you are Joseph Kraut, wave your hand. All right, thank you. What are we doing on this?
Thanks, Judge. This is a date and time set for PCC. To my knowledge, discovery is complete, and we would be asking to have this matter set for an exam.
You don't have the witnesses available for
We'll do our best, Your Honor.
preliminary examination in person will be set for June 24th, 2025, 9 a.m. That's before
Judge Fleischer.
Judge Fleischer.
Thank you,
Bond
Judge.
will continue. Thank you. Sad. Ian. Court does call the case, people of the state of Michigan versus Daniel Bowers.
Morning, Your Honor. James McWheel, Special Assistant Attorney General on behalf of the people.
Good morning. Good morning. Kevin Badish on behalf of Mr. Bowers. Can you state your name for the record?
Daniel Bowers. Thank you. What are we doing?
Your Honor, may we approach, please?
I can't do that. He's, I don't have the capabilities of doing that.
It's about a potential conflict.
About what?
A potential conflict.
For who, your office or me?
You.
All right, let's go. Have at it. I don't know what that's going to be, but do this.
Sorry, Your Honor.
Court's going to stand in recess. Hang on, Mr. Attorney General. Throw me in the Attorney General. Go breakout room. You guys step up.
So sorry.
I've never done that. You may be saying this. Okay, thank you. Tell me.
That's exactly right.
Yeah.
Okay, girl. So.
Good, everything's up?
I'm thinking.
No.
Gentlemen. We know that.
I don't either, but so that the record is clear, apparently, and I had to go back in my memory, I played softball some number of years ago with Mr. Bauer. That almost has to be 15, 20 years ago.
30 years ago, sir.
Pardon?
All 30 years, sir.
Thank you for aging me.
No, sorry, I'm aging myself.
It was a long time ago. I did not even recognize it when he came out. I did not recognize his name. It will in no way impact the way in which this court would handle the case.
Understood, Your Honor. Thank you.
He played shortstop. Go ahead.
I'm gonna act like I know what that means.
What do you say? You don't know what that?
I'm gonna act like I know what that means.
Not a very good shortstop.
Really? There's only like 9 positions. No. Seriously?
You know, my husband just got me on football. It's too many positions there. I'm just gonna stick to that for now. No baseball for me.
You just go from right to left, and then you just go by the bases. Shortstop's the only odd one out.
Okay.
I remember.
I'll send you a diagram.
Thank you. Thank you so much.
And I want to apologize, sir. I was not a very good shortstop. But you did play me.
I know. All right, no, okay. All right. You're looking for an adjournment.
Yes, and a chance to address bond whenever there's a minute, Your Honor.
All right. I will adjourn the matter to June 26, 2025, 9 a.m. Yes, as to bond.
Your, sorry? Okay. Your Honor, Mr. Bowers receives Social Security. He receives 100% disability right now. If he is in custody for more than 30 days, he loses the Social Security and VA disability benefits. Right now, I mean, this case is relating to child support, and right now he could pay the $2,300 a month child support obligation, but if he loses those benefits, it would be very difficult for him to come up with the money to be able to honor those obligations. We are going to be asking that
He could pay what the current obligation?
He's making payments towards the amount that he owes, correct?
Yes, I can. I can, as of now, Your Honor.
He also has no criminal history in the past 15 years and lives with his nephew in
Corpus Christi, yes, ma'am.
Well, the problem is, as the complaint read, there was about $61,000 in child support that was due. And I think his bond got set at an amount of about 25% pursuant to statute. I don't know that would constitute any reason for the court to change that. And I don't know that I could necessarily under the terms of the statute at this point. So I don't need a response from the Attorney General. I'm going to deny the request for change in bond. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case, People versus Demond Bransford.
Good morning, Governor. Ashley Lonnie for the people.
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Bransford.
I'm going to assume that was his name. Go ahead, Ken.
No problem, Your Honor. At this time, we'll be requesting an adjournment. Mr. Bransford's been referred to the felony drug treatment court, so we just need some time to have that process going.
And he's not already in that court?
He's not already in that court. I filed the referral. I sent the referral over to Christina Sample on Tuesday.
Got it. Probable cause conference without objection will be adjourned to July 3rd, 2025, 9 a.m.
And I do have a green sheet for you, Your Honor.
Pardon? Okay. I need the green sheet. Bond will continue.
Thank you, Your Honor.
Thank you.
Thank you.
What does call the case, People versus Robert Connolly?
Good morning, Your Honor. Jacob Kennedy, on behalf of the people.
Good morning, I'm Rob J. Kilmer on behalf of Mr. Connolly on all four matters. Judge, I met with this young man last night. We had a long talk. We'd like to set this matter for exam.
We have all of the discovery.
Yes, Your Honor.
People have their witnesses available the 24th?
Do our best, Your Honor.
Pardon?
We'll do our best, Your Honor.
Preliminary examination in person will be set June 24th, 2025, 9 a.m. That is before Judge Washington. Bond will continue.
Thank you, Your Honor.
Talk to you.
Did you need? You have something?
Yes.
Court does call the case of People versus Kevin Chivare Lowry.
Ready, Your Honor? For those two people.
Shannor.
Good morning, Your Honor. Charlotte Stephan on behalf of Mr. Lowry.
Morning. Your name?
Kevin Williams, Shannor Lowry Jr.
Thank you. So, all right, what are we doing?
Your Honor, we do not have discovery completed yet, so we are respectfully requesting an adjournment of the PCC. There is also one issue regarding a bond condition. I did have a brief opportunity to speak with the prosecutor, and we may need to address this at the next court date, but I wanted just to bring it up now.
Probable cause, will 2 weeks do? That'd be enough time for you, Mr.
That is good for me, Your Honor.
Probable cause conference, June 26, 2025, 9 a.m.
And, Your Honor, the bond condition was just regarding
returning to his residence at his mother's house, and his mother is present. Apparently, that was the location of the alleged incident in this case. According to my client and his mother, the complainants do not reside there. I think the people may need some time to look
Not
into
to
that.
verify that.
Yes.
All right. We can raise that the next time when they have a chance to look at it. All
Okay.
right, Bond,
Thank you,
we'll
Your Honor.
continue at this time. Thank you. Court recalls the case of the People versus Spencer Norton.
Alexander, on behalf of the people.
Pardon?
Good morning, Judge. Jeff Perlman on behalf of Spencer Norton.
Mr. Norton, can you state your name, please?
Spencer Norton.
I don't see him at this point, but he was there. All right, what are we doing on this? Up there he is.
Judge, I believe this matters, the court, before the court are a misdemeanor matter and a felony matter. If I'm not mistaken, I would like to set the misdemeanor matter for a bench trial and schedule the,
Well, I don't. Do I have a misdemeanor?
Do you want to aware, Your Honor, I believe all the 4 cases were recently arraigned.
Got it. Mr. Perlman, you're on the fleeing and eluding 4th degree case, correct?
correct.
Okay. Was he arraigned on those?
He was.
So he's been arraigned on 3 other cases.
Okay.
And I don't know if you were aware of that.
I was aware that he had 3 other cases. I'm happy to hear that he's been arraigned.
I'm sorry?
I was aware that he had those 3 other cases, and I'm happy to hear that he was arraigned.
Okay. But you are not representing him on those, is that correct, sir?
Not at this time, correct.
All right. So what did they do at arraignment? They didn't,
I don't think he's not present. Check that.
what?
I will check.
Well, he would have gotten the PD.
He just says that no counsel was present at arraignment on June 2nd.
Well, checking your log notes stop me from blowing a gasket, so there'll be no need. Mr. Brown, Mr. Norton is here. Mr. Perlman represents him. He has 4 cases. Mr. Perlman represents him on one of the cases. I think I closed it. It's the case ending in 357. He was then arraigned on 3 other cases. And I don't even know what happened, and I'm afraid to say, and I'll probably say something that hurts somebody's feelings. So he doesn't have counsel.
All right, then.
And which means he should have been given the PD at that moment.
Okay. And where is Mr. Norton?
He's in Livingston County Jail. Mr. Norton, do you want to be represented by counsel on those other matters?
For now, yes. I'm pretty sure I'm gonna.
Pardon?
I think I'm gonna retain Jeff on those. I just have to wait for my family to get back in town. But for now, yes.
All right. So,
All right. Your Honor, Lauren Brown, Deputy Chief Public Defender, appearing on behalf of Mr. Norton. What we're going to do at this time is ask for a 2-week adjournment, if everyone is in agreement with that, so that we can get the discovery, and if Mr. Norton retains Mr. he'll have a chance to see the
then
discovery
there
as
can be
well.
the substitution done.
Could we just,
On the one case that you have, I don't have the misdemeanor case in front of me, Mr. Perlman. That's probably out at the Chelsea court.
okay.
With reference to the felony, you have an objection to adjourning it 2 weeks so we keep everything together?
Could we just set everything for preliminary? Honestly,
I would
I don't
just
do
ask,
that until all discovery is complete, sir.
Everyone would need to have the discovery and know what the charges are.
so I believe in
Before we consider.
I believe in the fleeing fourth, the case that I'm representing mine, we do have the discovery, so if possible, Judge, we would be requesting an exam on the fleeing fourth.
That's right.
In that case, I do believe there's outstanding, 911 calls that had the officers coming out to the scene, and those have not been received yet by me. They were requested, but not received yet.
So there is outstanding discovery on those, Mr. Perlman. The 911 calls.
Okay, would it be possible to send those before the exam?
Okay, so here's the way I do it. I make sure that discovery is complete, because once you get to exam, the judges here are going to be very reluctant to adjourn because you don't have discovery.
I understand, so I have no objection to a 2-week adjournment.
Probable cause conference in these matters then will be adjourned to June 26, 2025, 9 a.m. Bond on all of these matters will continue. Thank you.
Thank you, Judge.
Thank you.
Court does call the case, People versus Christy Couch.
Oh, she's here. There are 4 defendants in this matter. I think you probably want to call all 4 cases at once. Because we're going to be setting an exam date, and we're going to need to have calendars.
Right.
Andrew Shiller's bank.
Yeah, and I'm the self-appointed.
Well, yeah, but I get sick of people telling me how to do this. I've been doing it for a while. Who are the other attorneys?
Sam Bernstein, Hannah Apple, and Mr. Norman, is it? Yeah.
Have you guys tried to figure out a date?
We didn't know what day of the week the court would want to do it, whether Tuesday or a special day.
All right, all councils here, council approach. You have all their files. Pardon? This conference in this case, court's understanding is discovery is complete, except for one counsel that's picking it up today, but discovery is complete as it regards that. The people would have their witnesses available the 23rd, or will make the best attempt. I will set preliminary examination in this matter for June 23rd, 2025 at 11 a.m., and that is before me. And in this case, bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case versus Myron Couch.
Good morning. Michael Norman, here on behalf of Mr. Couch, who is present.
Your name, sir?
Myron Couch.
All right.
And I believe we've discussed the exam date already. We did want to address bond. Mr. Couch is obviously the co-defendant with the prior defendant that was called Christy Couch. They've been married for 28 years, have children in common. They have a no contact provision as part of their bond conditions. I don't think it serves any legal purpose. They can't be compelled to testify against each other. And so the no contact, I don't believe it's serving any purpose. I'd ask the court to lift that. Their daughter just graduated. They have a graduation to go to. They're going to be in the same areas. I just don't want him to violate his bond based on being near his wife of 28 years. If I could address the court briefly, I represent David I. Goldstein, on behalf of Christy Couch, who is an interested party to this issue, Your Honor. One thing that Mr. Norman present to the court is the two of them run a business together. It is the sole support of their families. She's been trying to maintain the business, but it's very, very difficult because it involves live animals.
to be able to do it without Mr. Couch's help, or with the two of them being able to do it at the same time. So we wanted the court to aware of that also.
Exotic puppies, Your Honor. Exotic dogs, Your Honor.
Dog breeding.
Exotic dogs.
Yeah, fancy dogs.
Expensive dogs.
All right, people have a response.
Candidly, Your Honor, although I never got a police report to this effect, I believe it was probably violating a contact order anyway, based on information relayed by a witness in the case to the office. But without a police report and investigation, I'm not bringing that to the court's attention. I am, but I'm not asking the court to do anything. I leave it up to the discretion of the court, Your Honor. Obviously, we have an examination in a fairly short turnaround.
Yeah.
If I had my preference, I would ask it remain into effect and it can be addressed after the preliminary examination is held before Your Honor in about 10 days.
And I think that's what I'm inclined to do since we'll be back shortly. But, Counsel, you indicated that there were graduations, but they're able to attend, but not together, right?
Right, I just want to make sure that they're not going to try to violate them for being, in the bleachers near each other during graduation.
Graduation, where is it?
The graduation party, right, yeah. And where is that going to be?
It's going to be at the port.
Right, so they're having graduation party at Metro Park, and so I don't want them to violate for being both at the park for their daughter's graduation.
I'll tell you what, I'm going to deny your request at this time. If the people raise the issue of them being at their child's graduation, then I'll address that. I think they know how I come down on that, so.
Thank you, Anna.
Thank you. Court calls case People versus Deon Gates.
Andrew Childress, appearing on behalf of the people.
Morning, Your Honor. Sam Bernstein with and on behalf of Mr. Gates.
It's going to take it may take a little bit of time, so let's put that at the end. And if you can go do some other, take care of some other business, I'm sure you're busy on things, then come back, and then hopefully we can get right into that. Okay.
Well, I'll be next door, Judge.
Who's the prosecutor on this? Mr. Ham? Sir, thank you.
Thank you, Your Honor.
Okay, let's go to Diane Ruben, please. John?
It'll be really quick.
Huh?
So I'm gonna be really quick.
Oh,
She's not even brought over here on this status of what we're trying to do with her. I'm still working on it. I've been trying to find out about this money she's been getting. Remember we talked about it last night?
Help me out. Let's play like I had no other case.
She is, she was found incompetent, found incompetent, back forth. She committed new offenses while she's on probation. I think the last status, she's competent, but she's.
And we already had the hearing.
Yeah.
We've asked for her to be revoked, Your Honor. I think the court was trying to look for, because she is competent and she's been found to be competent, I think our hands are kind of tied as to what we.
But it's not really, even though they said she's competent, if we release her, what's going to happen? I mean, she's not really going to take care of herself. And she's an elderly lady. She's a lot younger than she looks, but and she's the only one to go to a home. She requested to go to some kind of home. The problem is, who pays for that? How's that going to work? That's the big question. Because or do we send her to prison?
We have a motion to revoke probation pending. Well, we got to hear that.
We've already had a hearing.
And where's the order on it? Did we do? There's an order.
You didn't make a ruling.
Okay, we're just trying to find
last.
Then
put her on hold for us to try to find some.
Was it a week ago? A month ago?
No, it was less than that. It was like 2 weeks ago or something.
This is 5:15.
This is now. Time flies when you work it.
No, it would have been a month ago.
Yeah,
30 days.
You're right. Yeah,
31 days.
Well, my request today is for today's hearing is that if I can get about 2 more weeks, Your Honor, I'll make some.
Where is she? In custody?
No, she's a judge. They didn't bring her over today.
Yeah, but she's in custody.
She's in custody, yes. Yeah, she's been in custody for a long time.
think we were also trying to figure out where her check was going to.
That's part of what it, yeah. Find out
Anybody
what
find that out?
I'm working on trying to find out because it's going to an individual. I don't have the name of the computer over there. But who's not related to her. I'm trying to figure out why he's, that's what we're trying to do.
That sounds.
And, Matt Turner also has been working with Matt Turner upstairs too, from the state side. Trying to figure out what's going on with this.
One case may turn into two.
Yes, there could be something. That's reason Matt's working with me on that to try to figure out.
Wouldn't be the first time that a person illegally took advantage of
Somebody
somebody
who was in
who they thought would never miss the money.
Yeah, a vulnerable state because she's been in jail. So, but she could take government check and try to figure out where that's going. And that could, if we get that straightened out, that could go to pay for some kind of facility for her. I think that's the big issue is that we gotta get together.
So my next event.
2 weeks, just another stats like this.
What's the state saying? Anything to add or any objection to that?
No, Your Honor.
Okay, let's reset 2 weeks. For Ms. Rubin's case. Sis. Wow. Okay.
Yeah, we got through it.
Are you supposed to, I thought you were supposed to be better.
That's what my doctor's note says. I should come back to work today. You confused me then.
So Stan.
I don't got to go. Yeah, so you have to.
Deon takes us Stan.
This is
3 cases.
Oh, I didn't see the holler, but you're right. I hadn't seen them today. You think about me? I think that's well, that's my, I haven't seen that. He was out.
He has a new case. I just gave you discovery on today.
There's a
25 ECCR.
593?
Yeah.
Yes, I see it on the document here. Yeah, okay, well, I need some time to go over that. I just got discovered over with him, so we get another announcement and
it was.
Well, I mean, a deal announcement, so if you enjoy. So she got discovered today, Your Honor. I'll have it.
Okay, 5 TDC. Considering he's picked up 3 deadly conduct.
Yeah, well, like I said, originally, I was disappointed. I think you just need to.
Yeah, for spike.
Okay.
And just in case of this, I think we need to be required.
Send CC on all of
Yeah.
Where is he in custody, you said?
Yes.
Because these first two are on at the same top, on the same day.
Yes.
And then this one comes about 9 months later. It's like,
yes, and
Yes, last month.
there's also one that kind of the same kind of thing.
Yeah, no, read the facts and then you know it's fine.
Did you consider the sheriff should get more? The officers.
He left his ID on the scene.
How do you know? Was he having out some?
Judge, it does look like he was on bond and then first doing the, or that's what it's committed.
what happened on that third one? What's the bond on it for that? Or is there no bond?
The new one? The new one, his bond is $100,000, Your Honor.
He's indigent.
John, I'm appointed, so I assume he's. I have no reason to believe he's not. I mean, I'm appointed here and actually in Hardin County both, so I'm
He's got a Hardin County police?
Yes, he did good on the first 2 cases, Judge. Those are $10,000 each.
Mr. Nix was appointed to represent him up in Hardin County, but when he found out that I represent him here, he passed over to me, so.
Okay, looking at these two, sets of cases, three cases out of two different events. And on, the second event is remarkably similar to the first event. So the bond is $100,000. What we're going to do is, I'm going to add to those conditions, those bond conditions. If he should make a bond, he's home confinement. He has to have a GPS device on him, or additional, and he can't leave his house except for medical needs or food.
Or legal court, stuff like that.
Or legal.
Yeah.
And he must operate, if he does leave,
Most direct route.
in the most direct route possible to and from the location. Plus, he has to alert the people who have provided the GPS device prior information about him leaving his house before he leaves, unless it's an emergency. But this is very disturbing. This is terrible. But so you've asked for 2 weeks?
Yes, sir.
You've got it. That's for an announcement?
Yes.
All right.
We're doing this guy actually right now.
Okay, thanks.
Yeah, you still got it. That's following.
Yeah.
You okay, Ricky?
Yeah, and then the tricks of car, they come with mobile connection, though. He's not a smart criminal.
Okay, you're the ones who do it.
Yeah.
Most of ours are not the same. Yeah.
That's tomorrow.
That's the one.
Yeah, he's been calling that for me.
Need something.
That's what I tell you. That's really.
Okay, we're in short recess. We still have this matter on Trevor Burge to take up when Ms. Coffin comes back, okay? Do you know anything about this, Mr. Ham?
I know she filed the next part time motion.
Yeah.
I know that.
I'm gonna have to deal with that with the court reporter in chambers.
I would just remind you. I would just remind you that she's hired.
Yes.
That's my only input.
Okay.
And I'm ready for a hearing whenever it is.
On the motion to revoke probation?
Sooner the better.
Are you ready today?
I could be. Give me a few minutes to get my witnesses here.
No, that's what we're gonna do first, is the MTRP.
My preference is set it next week.
We'll talk with Ms. Coffin when she gets here and.
Yes, sir.
About scheduling, okay, everybody?
Yes, sir.
Short recess, thank you.
Yes. Prepared to proceed to the exam date on June 23rd at 11. This is for someone else, sorry.
Yes, in the last case, if I didn't say so, that preliminary examination in that case, as well as this case, will be set for June 23rd, 2025, 9 a.m. That is before me. That is in person. Bond will continue. Thank you. I got one more. Okay. Court does call the case People versus Daryl Frederick.
APA Rachel McDuffie for the people on all
6 matters.
Edward Droops for Daryl Frederick, 7 and 5526.
And good morning, Lauren Yagi, Assistant Public Defender, with me on behalf of Mr. Frederick in the 4 remaining matters.
All right.
Your Honor, I have written discovery. I don't have any video. I'm asking for an adjournment for that purpose and for further negotiation.
And Your Honor, for the record, we would ask to adjourn our cases along with those.
I will then adjourn all of the probable cause conferences in this case to June 26, 2025, 9 a.m. Bond will continue in this case.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Court does call the case People versus Shaniah Williams.
Alexander on behalf of the people.
Sam Bernstein for Shaniah Williams. Just for Shaniah Williams, Judge. I didn't have any good contact information for her. Nothing worked. So I'm hoping to adjourn this 2 weeks to get in touch with her, Your Honor.
We'll help you out with that. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of 10,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor. Have a good rest of your day.
You too. Court does call the case People versus Jamal Matthews. Let's see how. Huh? Got her.
Andrew Childers appearing on behalf of the people.
Attorney Trevor Burge requesting permission to practice under Michigan Court Rule 8.120 under the supervision of APD Hannah Apple on behalf of Mr. Matthews.
Permission to practice is granted.
Thank you, Your Honor. Mr. Matthews, could you state your name?
Jamal Matthews.
All right. And in this matter, we had, before we came out, there was a bench conference that included your counsel, sir. We were going to set preliminary examination in this matter. We're going to set it for June 23rd, 2025, 9 a.m., and that is before me on a special day. Bond will continue. Thank you, sir. Court does call the case People versus Brian Gerard.
That's for the people.
Edward Droops for Ryan Gerard, who should be approaching shortly.
Oh, I called somebody in custody. He's in,
Yes.
but they were taking somebody back.
He is coming up now.
Your name, sir?
Brian Gerard.
Thank you. All right, what are we doing?
Your Honor, I believe discovery is completed this time. I'd be asking for a preliminary examination.
People have their witnesses available the 24th.
the best.
Preliminary examination in person, June 24th, 2025, 9 a.m. That is before Judge Fleischer. Bond will continue.
Thank you, Your Honor.
Court does call the case of People versus Christopher Atkins.
For them.
Christopher Atkins. Yeah. Sorry, Judge.
This is Mr. Atkins. I apologize. Your Honor, Mr. Atkins is in the Livingston County Jail. I was able to verify that on VineLink yesterday and then again this morning. So I'd ask that the court adjourn this matter to allow him either to be written out for a hearing or ultimately to be released
June
from the jail.
26, 2025, 9 a.m.
Thank you, Your Honor.
Thank you. Bond will continue in this matter. Court does call the case, People versus Shannor Harris. 3 cases.
As on behalf of the people, Your Honor.
Good morning, Your Honor. Edward Lucas on behalf of Shannor Harris in all 3 matters.
Your name?
Shannor Harris.
Thank you.
Government briefly, Coach.
Can't stop here, come on. I already revoked your phone. It's available in 20 video that's outstanding, but it may or may not exist. And Mr. Drew, could you like proceed forth
Yes, Your Honor.
about that? All right. People have their witnesses available in 24.
We'll do our best, Your Honor.
Preliminary examination in person will be set June 24th, 2025, 9 a.m. before Judge Washington. Bond will continue on these matters. There was an issue raised. Harris, I had already revoked your phone privileges in this case. My understanding is that you're going through a mechanism to continue to make calls from the facilities. All of those calls are tracked, so I don't know why you're doing that. I want you to know that once the jail receives communication from the prosecutor's office about that continuing despite my order, they're going to take further action against you within the jail administratively. You understand that, ma'am?
Yes, sir.
All right. Thank you.
Thank you.
Court does call the case People versus Roger Bates.
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Bates, who is appearing via Zoom.
Is it? State your name, sir.
Robert Bates.
Yeah. What are we doing?
I'll be asking for an adjournment. We're looking for some possible outstanding video discovery as well as for time for pre-negotiations.
Gotcha.
Yes, I do. Thank you, Lee.
Probable cause conference will be adjourned June 26, 2025. 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court does call the case People versus, is it Valerie Hennings?
Hey, here, Richard McGiffin for the people.
Good morning again, Your Honor. Christina Costantino appearing with and on behalf of Mr. Henning. Mr. Henning, can you please state your name for the court?
Nasia Hennings.
All right. Okay, what are we doing on this?
Judge, my client.
Go ahead, Ms. Costantino.
My client is the co-defendant of Seth Pester, who you scheduled for a preliminary exam on July 15th. We would ask that you do the same.
All right. Preliminary examination in person, July 15th, 2025, 9 a.m. Who did we set that before?
Judge Moore, I believe.
Is before Judge Washington. No. Moore. Before Judge Moore.
Got it.
July 15th, before Judge Moore. Thank you.
Thank you.
Court does call the case People versus George Bauman.
And is that on behalf of the people?
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Bauman. Bowman, I apologize.
Your name, sir?
George Bowman.
All right, what are we doing?
We'll be asking for an adjournment to determine if Mr. Bowman is admitted to drug treatment court as well as for further pre-negotiations.
Is that the felony jail court?
Yes, it is. I did speak to APA Nowakowski, from our office. It sounds like he'll be talked about at the meeting on the 26th, so I'll be asking for a week after that.
Probable cause conference, July 3rd, 2025, 9 a.m. Bond continued.
Already down.
Court calls cases of the people versus Zachariah Harris Dennis.
And again, people, Your Honor.
Christina.
I'm appearing with and on behalf of Zachariah Harris Dennis. Please state your name for the record.
Zachariah Harris Dennis. You want to sneak in there, Miss Constantino?
Thank you, Judge.
Yeah,
Christina
no, it's okay. Those young bucks come up and they just start butting in and
That's all right.
Go ahead.
That's all right. I love it.
Your Honor, at this time, we are requesting for a 2-week adjournment due to pending AIM referral. We are waiting for one more video, but 2 weeks should be sufficient.
Miss Constantino, in your case?
Judge, I would concur with that request.
All right. Probable cause conference, June 26, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you very much, Judge.
Thank you. Court does call the case of the people versus Zaria Brand.
Alexander, on behalf of the people, Your Honor. Student Attorney Kara Rosengren, Supervision APD and Apple. On behalf of Ms. Brand, could you state your name, please?
Zaria Brand.
Your Honor, we're going to be asking for an adjournment as we're continuing plea negotiations.
June 26, 2025, 9 a.m. Bond continued. Let's call the case people versus Gun Melhan.
Good afternoon. Good morning. I'm Rob J. Cole on behalf of Mr. Milhan. Glenn, would you state your name?
My name is Glenn Milhan.
All right.
Judge,
before we begin, his case, and I'm not even sure how it happened. You have a PD case for him too. You only have one. Don't worry about it. Mr. Kilowald, you're on case ending in 0704.
I believe so.
Okay, I'm just stepping in for APD Virgils on this case on behalf of Mr.
All right.
Milhan.
All right. So that the record is all clear. Mr. Kilowald, you're on 0704.
Correct.
Somehow or another, and I'm not sure how this happened. His case got sworn to twice, and I think he was arraigned twice on it. That's why we have two cases. But the latter case ending in 749 is a duplicate of the case which Mr. Kilowald has. So one of these has to be dismissed.
Judge, I talked to a sign. I'm sorry. Pardon? I'm sorry?
It was dismissed? When? Yeah, it should be, but it hasn't been. But I need a motion to dismiss it because I have an open case.
Your Honor, just for the people who dismiss the case in 0749, as it is a duplicate.
Thank you. Case is dismissed.
Thank you.
All right. That case is dismissed. All right. Now,
Okay, Judge, I was appointed, this is gonna be a little bit of a long story, but I'll make it quick. Okay, I was appointed on Monday. I do have the discovery. I know Glenn, he wants to have a preliminary exam as quickly as possible. I started jury trial with Judge Kuwante on Monday. I told him so we could do it next Thursday. I would not be available Tuesday if the court were to, a preliminary exam on next Tuesday. That being said, if you can't, then we will go out to the next available date.
The 24th?
Correct.
South Carolina, so you need to, kind of find her.
She does not live in, she does not, just relax. Judge, let me just say this. This is a case of a homeless lady who keeps coming to his apartment. I don't condone violence against anybody. She was asked nicely to leave. She's been there. She keeps showing up. He doesn't know what to do. And there's allegations that he hit her over the head with a fire extinguisher. And all the pictures show a split lip, which she had before she met him. So again, I'm not minimizing what happened. And yeah, and she cut him leaving, so.
The information I have is that she does live out of state, and I would note that, the defendant, actually, has several prior convictions and was on bond when picked up this case. And there's a third party witness who corroborated what the victim said. So, my information is.
Well, how soon can you, I'm on the 12th. So, well, I'm on the 12th, so you can't get her here by the 24th?
Possibly the 24th.
I mean, that's the date that I would next set. So
If that's the earliest date, that's fine with us. It's just, we just believe, again, I can sympathize with somebody who's homeless, but.
Well, two things. Can you get her here by the 24th?
Yes, Your Honor.
All right. And is he being held on anything else or no?
No.
All right. Here's what I'll do. I'll set the earliest complete discovery is complete in this case.
Judge, may I address bond?
And I'll set preliminary examination in person. June 24th, 2025, 9 a.m. That will be before Judge Fleischer. Okay.
Judge, I believe his bond's $30,000. He's on Social Security. He had planned to register into Washington Community College. He's not a flight risk. He had been on tether. There have been no allegations. Again, this whole thing blew up over this homeless lady. Again, we're just asking if you would give.
I'll hear you on everything, but was he on bond at the time of this offense?
Yes. Yes, Your Honor. He has a circuit court case, but I don't believe there's been a violation of a bond filed with circuit court yet.
But he was on bond at the time.
He was, Your Honor. But I would still ask, Your Honor, and again, I mean, I understand their position, but this is something of a lady coming into his house and him asking her to leave. So I'm asking if the court would consider a reasonable bond, Your Honor, even 10% bond of $30,000.
Any response again from the people?
Your Honor, my response is that he's actually on two separate cases in circuit court. Case 24-831 and 24-832. And 831 is charged with aggravated stalking, which is destruction of property, 200 to 1,000. And then in 832, he's charged with aggravated stalking, which is use of telecom. Your Honor, he has several prior convictions that are concerning 2004 FA, 2005 was like already assault with intent while armed, so both armed robbery and assault with intent while armed. 2013 DV, 2013 misdemeanor stalking, 2021 misdemeanor stalking, 2023 misdemeanor stalking, 2024 misdemeanor stalking. And so that's on top of the two that he has. And so, Your Honor, he was on bond when he's alleged to have done this. And the victim indicates that while she was in the residence, she was in the room belonging to another person who lived there listening to music. That person indicates as well. They were in his room listening to music, and then Mr. had forced his way in and then hit her in the head with a fire extinguisher. So, Your Honor,
I want to talk. Anything else, Mr. Cole?
No, Your Honor, I would like to address the issue being,
I don't, sir. Okay. I'll just say this. I don't mind hearing from anybody, but I don't want you saying anything about the case that may jeopardize your case.
I don't feel that it'll jeopardize me, sir.
I know, but you probably figured that out with your law degree, haven't you?
I get
You
it.
got it? Okay.
Can I have him?
Judge, I think
Go ahead.
he's trying to say that he was cut by this lady and he was gracious enough not to call the police. Now in turn, she's called him. Now he's sitting in jail. This due process he wants to run by. We discussed it early last night. I told him I would say something to the court, but we're ready to go to exam
I
on the
mean,
24th.
he's currently on bond on other matters, has a record. And given those two facts that he's on bond on 2 cases at the time of this alleged offense, I'm not going to change his bond. I'm going to leave his bond. I think it's appropriately set at this. All right. Thank you. Court does call the case, People versus Cordell Brown.
Malika Fatima, appearing on behalf of Cordell Brown.
Where's your client? Don't tell her. Don't tell her. Don't tell her. She had no idea.
Appearing via
Had
Zoom.
no idea. She's staring around the room.
Appearing via Zoom. Thank you.
She didn't know that. When she walked up, she's looking around the whole room. Leave her alone. She's doing just fine. Why are you calling her? Just leave her alone.
I'm making her feel like she didn't make it.
Because she didn't.
She did. She's amazing.
Oh, so everybody's gonna just like jump on the bandwagon. You got more cases, don't you? Yeah.
Yeah.
Yeah, okay, all right, keep jumping on that bandwagon. Some people are just gonna have a long day. Go ahead, counsel. Ma'am, could you please state your name? Or sir?
Cordell Brown.
Thank you. All right.
Thank you, Your Honor. We are requesting an adjournment for 2 weeks due to missing media discovery. And he is currently patient in a psychiatric facility.
Said that with a great deal of confidence. Okay, Dadu, go ahead.
Your Honor, he's just appearing because he's inpatient at a psychiatric facility. That's all. It didn't have to be placed on the record.
She got it.
I know, I don't know why you're up there. She,
Discovery for 1,000.
what?
We'll take missing discovery.
I'll adjourn this out to June 26, 2025. 9 a.m. Bond will continue.
Thank you, Your Honor.
You're welcome. So I thought you were working under the supervision of Apple.
We are all one.
Well, no, you're not all one. No, you're really not. But, so why is that dude your protector today? Never mind, we'll talk about that later. Hey, Kenny didn't seem to care. Let her go. What?
That's Lauren's in there. She doesn't make it.
So, well, what were you doing?
I was supervised.
AKA napping. All right. Court does call the case. People versus Anthony Alfaro. Is it Callejas?
Maybe Richard McDuffie for the people on both matters.
And Assistant Public Defender Nicholas Buckevitz on behalf of Mr. Alfaro Callejas on both matters.
Your name, sir?
My name is Anthony Alfaro Callejas.
Go ahead, counsel.
At this
You
time,
received the bond violation report.
I have not received the bond violation report.
It's a new case.
It is, but it is the new case, so I'm aware of it.
It is, yes, okay, good enough. All right.
As it relates to what we're going to do here today, we'll be requesting an adjournment in video discovery in the new case. I've already discussed that with the APA, and discovery request has been sent.
Say the last part again.
I've already discussed that with APA McDuffie, and I know the discovery request has been sent.
All right. So you want an adjournment in both matters?
In both matters, so we can keep them tracking together. I think that'd be the best way to ensure everything tracks.
Public cause conference will be adjourned June 26, 2025, 9 a.m. Continue.
I was gonna address bond if I may, Your Honor. I do understand.
Okay, go ahead.
I do understand, there's the alleged bond violation, but I wanted to ask for a reduction in the bond from the bond denied. My client works full-time as a manager at a Mexican restaurant where he handles issues such as payroll that so his lack of being able to work impacts other employees. He would be able to do this work from home. I know the APA would likely ask for a home confinement tether. He does work to support his family and is a primary supporter of his mother and sister, who he helps pay for various costs in their life, including rent. He has been taking courses within the jail on various topics such as algebra and domestic violence. He has been working to ensure that he continues to better himself while in custody. So I'd be asking for a reduction in bond with release on a home confinement tether.
I have 3 basic allegations of how he had violated his bond previously. I don't need a response. Motion for bond reduction denied. Bond will continue.
Thank you, Your Honor.
Thank you. Okay, take care. Is this business?
That is.
All she was saying is I love you, right? I didn't suspect it was forever. Forever. That's how Lauren Brown feels about me. Court calls the case, People versus Amanda Bryant. Oh.
It's not even much.
Oh, no. I'm gonna let you go. Go ahead. Thank you, Miss.
Kevin Douglas on behalf of Ms. Bryan stepping in for
Is this your
APD.
case or you just?
Not my case. I'm just taking everything.
Okay, go ahead. I'm
Taking cases, I'm giving cases. Your Honor, we are going, say your name for the record, please.
Amanda Bryant. Thank you, ma'am.
Your Honor, we are going to be asking for a brief adjournment for, discovery and lab result.
I don't know if I put this in the email, lab results could take months.
Okay. I will let APT Virgils know. I believe there's still photo.
Oh, so you are butting in. Okay, go ahead.
As usual.
Well, the lab results aren't something,
Now, there was a true narc of the drug stuff.
Yeah, so.
In my experience, they're not necessarily sent to the lab because of the long delay in processing, as well as MSD labs sometimes reluctant to test a small amount of items in exact cases. If the defense attorney is concerned that the true narc something is not what it is purporting to be, they can reach out and I can follow up. If that makes sense.
We can reach out after today. And we can reach out after today and discuss why it is that we need lab results. And I believe there's also photos that are missing.
Public cause conference will be adjourned June 26, 2025, 9 a.m.
Okay.
Thank you. Thank you, ma'am.
Thank you.
Court calls case People versus Sincere Godwin.
Your Honor, public defender Chinaki Kara Murley on behalf of Mr. Sincere Godwin.
Sorry to wake you. Go ahead.
Sincere, state your name for the record, please.
Sincere Godwin. Thank you.
Now, Judge, I wasn't involved in all of it.
What?
I didn't even say anything.
No, I'm telling you, I know. And that was a shock.
So, Your Honor,
You
today.
all ought to learn to act like this apple and just sit there quietly.
That's what I was trying to do.
Yeah, but it doesn't work for you.
I understand, Judge. Judge, today is the date and time for a probable cause conference. We are respectfully requesting that both of Mr. Godwin's matters be set for preliminary exam. We'd also like to address bond, Judge.
All discovery is complete on both of these.
2 hours, Your Honor.
All right. People have their witnesses available the 24th. preliminary examination in person, June 24th, 2025, 9 a.m. before Judge Fleischer. All right, yes, that's,
And as to bond, Your Honor, we are asking that the court consider, first and foremost, a PR bond for Mr. Godwin. And if the court is not inclined to do that, we would ask for a bond that Mr. Godwin would be able to post. His mother is present today. She is very active in his life and extremely supportive. Mr. Godwin was 18. Judge, I'll lead with what the court probably already knows. He missed court, and the court did set aside the bench warrant and give him an opportunity to appear 2 times.
I know.
Yeah. And unfortunately, he did not appear. Mr. Godwin states that he was working at the time. He was also in school. And Your Honor, I am asking that the court consider his age. He doesn't have much experience whatsoever. He doesn't live with his mother. He kind of thought he was wrong when he moved out of the house, but his mother's still trying her best to assist him as much as possible. We can ask for a tether of any sort. I understand the court's position on this. I have spoken with Mr. Godwin about that and explained to him that the court was more than generous 2 times to give us an opportunity to have him appear. I think that this experience has shown him exactly what happens when he does not prioritize his criminal matters or his court matters for that matter. And we're just asking that the court.
I don't need a response. I'm not going to change his bond. I mean, I gave him 2 opportunities. When we looked at it the first time, trying to give him a break, comes across again, trying to give him a break, and he still just doesn't do it. I don't have any reasonable degree of certainty that he's now going to do what he needs to do. So the exam is set in a few days, 12 days. So I'm just going to deny the request for a change in bond. His bond will continue. And then maybe Judge Fleischer after the preliminary examination will change that. All right. Thank you.
Your Honor. Okay.
Court calls case People versus Stephan Campbell or Stephan Campbell.
Jordan, under the supervision of Assistant Public Defender Jay Ballinger, requesting permission to practice pursuant MCR 8.120, without our client.
Hold it. Do me a favor.
Yeah.
All right. You've not appeared before me, right?
No.
I didn't think you.
This is my first time.
All right. I know. So do me a favor. First thing is just take a deep breath.
Okay.
Okay. Slow down. Do you have that all written down?
Yes.
You do? Yes. So you didn't practice it?
No, I did.
You did?
Yes.
So why do you need the paper?
Just my notes, Your Honor.
So you don't have what you're trying to say to me written down?
No.
Oh. Did Jay Ballinger tell you what to say?
No.
He didn't tell you what to say? Has he helped you at all?
Somewhat.
Wow. Here comes the bus. No, it's okay.
No,
it's okay. No, I appreciate your honesty.
I'm joking. Jay has been.
No, you're not. Jay has done nothing. We get it.
Found levers for dinner now.
Did you get her name already?
Yeah.
Okay. All right. All right. So go ahead.
We were not able to get a hold of our client.
Did she finish the other part? Well, yeah, I interrupted.
I didn't.
Go sit down.
I didn't want to say that, but yeah, I tried to.
Okay.
I tried to.
Whoa, slow down. You're confusing me.
Okay.
Start over again.
Okay. Good morning, Your Honor. Roga Hamden, under the supervision of Assistant Public Defender Jay Ballinger, requesting permission to practice pursuant MCR 8.102 without, 120, sorry. We are not
Our client is not present today.
Stop just for a second. You're requesting permission to practice under pursuant to Michigan Court Rule 8.120 under the supervision of Jay Bellinger. Is that correct?
Correct.
Where are you from?
Ann Arbor.
Ann Arbor?
Yes.
You go to high school in Ann Arbor?
Yes.
Where?
WTMC.
Okay, very good. All right, so you grew up in Ann Arbor.
I did.
Okay, then see, that brings you some benefit with me.
Yeah.
All right, so you'll do okay. Where'd you go to undergrad?
Wayne State University.
You're good. Where are you in law school?
Toledo Law. No.
So you were doing well. You were in Ann Arbor, you stayed in Michigan, and then you took off to the disputed territories.
I'm sorry, Your Honor.
All right, commissioner practice is granted. Go ahead.
Thank you. Our client is not present today.
Really?
What am I?
We went through all that and you don't have a client.
We do not have a client. I'm sorry.
Does Bellinger know where it is?
He does not.
That's what he told you,
We
right?
made every effort to contact our client. We could not get a hold of him. We do understand that there's a bench warrant that was issued June 9th, but we would like to request an adjournment on this matter.
We'll just leave the community corrections bench warrant out. That community corrections bench warrant is a no-bond bench warrant.
Oh.
The defendant having failed to appear. All right?
Thank you, Your Honor.
You know what? I feel so bad for you
Why?
because Bellinger knew that you didn't have a client and he sent you up there to get a bench warrant.
No comment, Your Honor.
All right. Wow.
Wow, sure.
Wow. Did that on purpose to her. Court calls the case, People versus Douglas Hill.
APA Richard McDuffie for the people.
Stephanie Cannon with the Public Defender's Office.
Almost. Your name, sir?
Douglas Hill.
Thank you.
And Your Honor, for Mr. Hill, we are asking for an adjournment. We also have an order for inpatient treatment that we're asking the court to sign. All of this has been presented to the APA in this case.
So this is
Mr. Hill.
what I'm calling the Yagi order.
Is that right? Is that right?
Right?
Is that a good thing, Your Honor, or?
No, it's a wonderful thing
Oh, okay.
that Ms. Yagi has taught the rest of you how to do that. I don't know how many times I had to say, I will grant inpatient treatment. And it wasn't until Ms. Yagi said, oh, well, I'll just prepare an order and have an order ready to go.
She is I think she's my mentor, actually.
She should be your idol. I will sign that order. I will also grant the adjournment in this case. And I'll set the probable cause for June 26, 2025, 9 a.m. Bond continue. All right?
Okay, we'll talk about it. Thank you.
All right, thank
Your
you.
Honor.
Court calls the case of the People versus Frank Clark.
Kevin Dadush on behalf of Mr. Clark, who's appearing on Zoom. Nope. Your Honor, Mr. Clark has not been able to be reached by our office. His phone number is disconnected. He lives in Ohio. The last time he appeared by Zoom, I was hoping he would appear by Zoom today as well.
That's what
I
happens.
hope he's okay.
People go to the disputed territory. Bench warrant will issue for defendant's failure to appear, bond 10,000, cash surety.
Okay.
Warrant will issue immediately.
Thank you, Your Honor.
Clerk calls the case of the people versus Stephen Johnston.
Oh, yeah, Assistant Public Defender with and on behalf of Mr. Johnston. Mr. Johnston, can you state your name for the court, please?
Stephen Michael Johnston.
Your Honor, I am asking for an adjournment. I do have a green sheet. I'd like to continue discussions, thank you, with Mr. Johnston as well as the APA. He does have multiple cases pending, so I think we just need more time to continue discussions.
Probable cause conference will be adjourned June 26, 2025.
Thank you, Your Honor.
9 a.m. Bond continued. All right. Court calls case people versus Deshawn Clifton.
Stephanie Cannon on behalf of Mr. Clifton. Mr. Clifton, when you are at the lectern, please state your name.
Deshawn Clifton. Thank you.
And Your Honor, we're asking for a 2-week adjournment in this matter. My client has met with our AIM division. They are preparing mitigation information to provide to the prosecutor.
Probable cause June 26, 2025, 9 a.m. Bond continued. Thank you, sir. Court does call the case people versus Christopher Nither.
And then on behalf of the people, Your Honor.
Working on behalf of Christopher Nither. Please state your name to the record.
Christopher Knapper, Your Honor.
Your Honor, we're requesting an adjournment on this matter, pending media discovery. We are requesting 2 weeks.
You have a green sheet?
I do.
And Your Honor, I believe it's, the media has been released by our office, so it's in the process.
Got it. Probable cause conference will be adjourned June 26, 2025, 9 a.m. Bond continued. Thank you. You want to respond?
We would like it to address bond, yes.
Go ahead.
We would like to ask for a PR bond. Our client has a minimal criminal history. He works for Instacart. He is not a flight risk. His father is in law enforcement and has the support of his family. He is able to stay at a friend's house in either Pinckney, Michigan or Ypsilanti, Michigan. Or in the alternative, we would like to ask for a 10% provision on the $5,000 bond.
Your Honor, I would object to any modification of bond. In this case, we requested 10,000. I believe the 5,000 at this time is appropriate. In this case, the defendant assaulted the victim at a gas station, which was witnessed by several people. He then forced her into his vehicle and put her back to the residence, also witnessed by several people in the area. When law enforcement arrived to check on the victim, they were not allowed entry. Eventually, they were able to get her by a window and grab her out of the house. At that point, they took her to safety. The defendant then refused to come out for hours. Eventually, law enforcement had to get a search warrant to get in the house and found the defendant hiding in the house. He has a previous dismissed case with the same victim for a GBH and MDO for the DB, and at this time, I believe bond is set as appropriate with respect to any modification.
Any additional response?
No, Your Honor.
Motion for bond reduction denied. Bond will continue. Thank you.
Thank you, Your Honor.
Court does call the case people versus Kuwante Cooper Walker.
And Lori Yagi, Assistant Public Defender with and on behalf of Mr. Cooper Walker. Mr. Cooper Walker, could you just verify your name for the court?
Kuwante Cooper Walker.
I got it. All right.
In your Honor, in this matter, we are respectfully requesting a preliminary examination date.
All discovery is complete.
To my knowledge, Your Honor.
People have their witnesses available the 24th. Preliminary examination, June 24th, 2025, 9 a.m. That is before Judge Fleischer. Bond will continue. You may go now.
Thank you, Your Honor.
Thank you. Court calls case people versus Alexander McMullen.
If you ever speak up for the people.
Am I judge on behalf of Mr. McMullen? Say your name for the record, please.
Alexander Mullen.
Kevin, that is stepping in for APD. Your Honor, we are going to be asking for an adjournment and we have on whenever appropriate.
Cause conference will be adjourned June 26, 2025, 9 a.m. As to bond.
Esteban, Your Honor, we are going to be requesting that he be released on his own personal recognizance or at least a 10% of what his current bond is, which is $5,000. Your Honor, he was gainfully employed before he went into custody. He works at a hotel in Ann Arbor. He lives in Ypsilanti. He has family in the area. He has a good supportive system. This is the only thing holding him. He just wants to be able to get out and, get back into work and make sure he doesn't lose his job.
Response.
Your Honor, I'm not certain if this actually is the only thing holding him. It looks like the bond recommendation form made reference to him being on parole for the past, I think, several months. I'm not sure if there's anything else you hold or not. In this matter. Okay, despite that, Your Honor, I think the bond is appropriate. Mr. McMullen has quite a few prior offenses. This is a clean case. I think some very dangerous circumstances with complete destruction of a large amount of pole, which kind of indicates the, I think, force and speed where he was traveling. Mr. McMullen has had quite a few prior cases, reduced, dismissed, set aside, all those sorts of things, and he sort of just continues to offend and offend over again. Over and over again, Your Honor. The history of offenses is not just limited to sort of fleeing and RNO types of things, but we got concerns about weapons and other things like that. In several counties, I have Washington, Lenawee, Livingston, and Wayne counties in terms of its history with adult and juvenile cases. Given that, I think the bond set is appropriate. And if there is a
is he on parole at this time?
Yes.
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 I don't need anything further. Motion for bond reduction denied. Bond will continue.
Thank you, Your Honor.
Court does call the case People versus Christopher Cummings.
Your Honor.
Malika Fatima with and on behalf of Christopher Cummings. Please state your name for the record.
Christopher Cummings.
Back. Okay.
Your Honor, at this time, we are requesting an adjournment for around 3 weeks if possible, due to missing media discovery.
Missing?
Pending.
Brown told you to say it was missing, didn't he?
Yes.
Cause conference, June 26, 2025, 9 a.m. Bond continued. Thank you.
Thanks, Your Honor.
Thank you, sir.
Thank you, Your Honor.
Court does call the case of the People versus Benjamin Peterson.
And on behalf of the people, Your Honor. Student attorney, Daryl Frederick, under the supervision of APD Hannah Apple, on behalf of Mr. Peterson. Mr. Peterson, could you state your name for the court, please?
Benjamin Donald Peterson. Really? Again? Zenda. Come on. Discovery be complete. People have the court does call the case People versus Amari Douglas. Does
Thank you, Your Honor.
court does call the case People versus Amari Douglas.
Anna Mackey requesting permission to practice under Michigan Court Rule 8.120 under Public Defender Brian Bowling.
Permission to practice is granted. We haven't heard from you all day.
Saving the best for last, Your Honor, for the 9 o'clock slot.
Wow, okay.
I'm kidding.
All righty then. All right. Your name, ma'am?
Amari Douglas.
All right. What are we doing?
Your Honor, at this time, we would like to set this matter for a preliminary examination and all discoveries complete as far as we are aware.
Discovery being complete. People have their witnesses available the 24th.
That's fine.
Preliminary examination in person, June 24th, 2025, 9 a.m. That is before Judge Washington. Bond will continue.
Thank you, Your Honor.
Court does call the case People versus Leanta Skinner.
Okay, Rachel McDuffie for the.
Student Attorney Kara Rosengren under the supervision of APD Hannah Apple. Mr. Skinner, could you state your name for the court?
Leanta Skinner.
Your Honor, we're going to be requesting that the court set a date for PE in this case.
I just want to ensure, before the court proceeds with that request, that Ms. Rosengren, is it?
Yes, no, that's right.
Is aware that Mr. Skinner previously waived 2 other cases, discussing with his other counsel that he had 2 more warrants that were coming. This is the 3rd of those warrants, and the 4th I just saw was thrown out on Monday. That the case is now in GIS for that police assault case. That doesn't mean that he's obligated to waive those 2 necessarily, but I just wanted to be sure she was aware that the final case is in GIS.
Has he been arraigned on the other case?
No, it's in warrant status. It looks like they just, I just saw this warrant on Monday. I wasn't aware it was done.
Your Honor, if it sounds like that is a felonious assault case, I don't think that has anything to do with, this is an embezzlement charge.
Got it.
So I think he still has to set.
You are. All right. People have their witnesses available the 24th.
Your Honor, we actually will not. My understanding is that I think the OIC on this case has been out on family leave for quite some time. I do not have an exact date for his return, although I think it would be by next month.
Well, that's going to cause a problem. Because is there anything else holding him?
I believe there's other cases. If I'm not mistaken.
Judge, he has matters in circuit court. I know at least 1 probation violation, and then he did waive some other matters for a resolution potentially on those. However.
And so those are holding him at this point.
Yes, I just don't know how, of course, he's in custody. This isn't the only thing holding him, but would have concerns if we don't even have a date of when that officer is going to be available.
Well, do we know when they'll be back?
Your Honor, I don't have a clear response. My previous discussion with Mr. Warren Green, who had Mr. Skinner's last 2 cases, was that his plan was to waive all 4 of these, and we were trying to get.
I don't care what his plan is. That's not the plan now. I need to know when's the officer going to be available.
So I don't have that response because that was not our previous plan. I will try to get that information as soon as I can.
Preliminary examination in person will be set July 1st, 2025, 9 a.m. That is before Judge Barr. Bond continue.
Thank you, Your Honor.
Court calls the case People versus Taiwan Griggs.
Again, we have Mr. Griggs, who is appearing via Zoom. Mr. Griggs, please state your name for the record.
Taiwan Griggs. Thank you.
Your Honor, respectfully ask for an adjournment pending further negotiations.
Probable cause conference will be adjourned June 26, 2025. 9 a.m. Bond will continue.
Thank you, Your Honor.
You guys have a blessed day.
Pardon?
Oh, you guys have a blessed day.
Okay, you do the same, sir.
Thank you.
Court does call the case People versus Linda Smith.
And then now we have the People
Brian Bowling on behalf of Ms. Smith, who's approaching, Your Honor. And then just state your name for the record.
Linda Smith.
Thanks. Your Honor, I'm asking for an adjournment in this matter for the discovery.
Probable cause conference, June 26th, 2025, 9 a.m. Bond continued.
Your Honor, may I address bond? Your Honor, Ms. Smith was previously on a personal bond with a GPS tether. There are some allegations related to some tether violations that occurred back on June 6th. June 6th. Based on my discussion with Ms. Smith and her mother, who is here today, Your Honor, the initial allegation of a violation of being in the exclusion zone was Ms. Smith was on a bus. Then ultimately, she was with her mother. There seems to be some miscommunication, misunderstanding on Ms. Smith's part and her mother's part as to what exactly was required of her once she was at the University of Michigan Hospital. Based on all that, and obviously subject to pending of a hearing, if that's the way this is going to progress, I would ask the court to maybe consider reinstating the tether, allowing for her to be re-granted a personal bond and ultimately be out of custody pending the resolution of this case, Judge. She did indicate to me that she does have a valid address where she can live. She's a young lady.
Yeah, but, okay. And you did have the report.
I did have the report, yes.
Go ahead.
I have concerns in this report. While I understand there could have possibly been confusion at the hospital. After they leave the hospital, they get to this address on Concord Drive. The sheriff's office responds, the defendant leaves the apartment they're in and tracks them, and they were tracked going into the woods, leaving from where the sheriff's had responded to. The sirens were activated and deputies were then able to locate her. I have concerns that she may be a flight risk, given that she left the apartment she was at when officers arrived. And given the facts of this case at this point, I would ask that bond remain set.
I'll just respond that it's my reading of that section with respect to the woods seems to be a bit confusing. I did discuss that with Ms. Smith. She indicated to me that she came through the woods to where the officers were at with her mother and ultimately surrendered herself at that point in time. That's our position. I'd ask the court to give her.
Where was? Okay. I think I hear what you're saying. So prior to coming through the woods then, if that's the case, where was she?
She had, but where had you gone?
I was in the apartment where I was on the street making my way towards my home.
She was trying to get, she had gone out, had walked down the street, was coming back to where her mother was at the apartment. She wasn't fleeing. She was just.
No, I understand. I understand that that's the point, but where, that still doesn't tell me where she was.
I think it's an apartment complex, correct?
Yeah.
I think she had just walked down the street in the apartment complex, Your Honor.
To where?
To where my mom was.
Where were you before that?
Oh, the
So you walked down to where your mom was, right?
Yes.
And then you're telling me that, did you go through the woods when you went there?
No, that was on the way to my mom.
So you walked through the woods on the way to where your mom was? Yes?
You had to say it out loud.
Oh, sorry. Yes.
And then came back that same way when to the officers or what?
No, the officers were with my mom at the time, and I was on the phone with her, so I was making my way to my mom.
Okay, so I see what you're saying. So the officers, your mom was on the phone with the officers?
No, they were with her.
They were there.
I was on the phone with my mom, and I was making my way to the officers and my mom while I was on the phone with her. She was
okay, and so you came back because you knew the officers were there.
Yes.
Is that a yes?
Oh, sorry. Yes.
Okay. Okay, so, young lady, when you're on the phone with your mom, right?
Yes.
And the officers are there, right, before you headed back, where were you?
Oh, I was in front of the apartment. The officers said that when I was on the phone with my mom, they
You gotta speak up a little bit for me if you can.
right. I was in front of the apartment and I was on the phone with my mom when I was let known that I had to turn myself in. So that after that, that's when I made my way towards them and my mom.
And that's when you went through the woods.
Yes.
So you were in front of the apartment. What were you doing?
Nothing. Like,
Pardon?
I was standing there and then when I was on the phone with my mom, I just immediately started making my way towards her.
You had just gone outside, correct?
Yes.
And you were in front of the apartment building where your mother lives, correct?
No.
Is that where you were? Or
Yes.
you were in front of the apartment where your mother lives?
Or at the place where your mother was located,
Yes.
correct?
Sorry,
Okay.
yes.
I apologize. The mother doesn't live there, Your Honor, so that was the confusion.
Okay. And then, so I just want to be clear on this. You're on the phone to your mother,
Yes.
right?
Mhm.
And so you're talking to your mother. And your
Okay,
mother
yeah.
told you
Yes.
that the police were there?
Yes.
And so when your mother told you that, you headed back to where your mother was,
Yes.
and you knew the police were there at the
Yes.
time. Anything else from either side?
Nothing from the people you're on.
No further from the defense.
And you know, when I look at this bond violation report, the whole Woods thing kind of threw me, but now I get what's happening. I think it's more important, and I believe the defendant that she's on the, otherwise, I don't know that she comes back that way where they are. She's on, somehow she knows to come back that way. So what she is also saying makes sense. That her mother is telling her the police are there. She doesn't take that opportunity if it was even in her mind to kind of flee, run away, do whatever. She comes right back to where they are.
To be frank, that's what concerned me, and that's what I questioned her about when we spoke yesterday, Judge, and that was the explanation I was given, which made sense to me as well.
I'm gonna grant the bond request. Her previous bond was a $5,000 personal recognizance, so I'll reset her bond to a $5,000 personal recognizance with a tether. I don't know if you don't have a tether on still, do you?
I do.
You do?
Yes.
Okay, so that tether will remain. So I'll set your bond at modified to $5,000. Personal recognizance, okay? All right?
All right. Thanks, Judge.
Thank you.
Thank you.
Court calls the case, People versus Tanya Hall.
Ashley Long, legal.
Oh, no.
Good morning, Your Honor. Audra Sabri requesting permission to practice pursuant to MCR 8.120 under the supervision of Chinaza Ikiri Akinruti.
Okay, permission's granted.
Thank you, Your Honor. Ms. State your name for the record.
Tanya Hall.
Thank you.
Your Honor, we are requesting an adjournment at this time due to a potential conflict with the file.
You do what?
A potential conflict.
What's that mean? Catherine really sent you up here to say that, right? Is that what she told you to say? She knows better. Go ahead, throw her under the bus.
No. After reviewing Ms. Hall's file, I decided that we need an adjournment for that reason.
Counsel approach, please.
They're gonna give me a roll.
All right, we're back on the record in the case, in the Hall matter. Ms. Hall,
Yes,
you haven't been testing, right?
no, I don't have the money to pay for the testing.
Okay. So if I find a way, and I don't know if it's gonna be possible yet, to get you tested today, because it's only once a month testing. And I understand there's a problem with your social security, right? Okay. If I get you tested today, if I can get you tested today, will you come back clean?
I'm not sure.
Okay. So what do you think will show up, Ms. Hall?
Crack cocaine.
Cocaine? You been using?
No, not really, but before I got arrested, I had used a lot. So it may still be in my system.
How long ago was that?
Like the day I got arrested.
I showed a rating date of June 5th, Your Honor.
So about a week ago, a week or so ago, you used.
Mm-hmm.
Okay, have you used since then?
One time,
One time? So when was that?
2 days ago.
Okay, so that's what may be showing up.
Yeah, might be.
All right. You know you're not supposed to be using, right?
Yes, sir.
All right. So we're gonna see if we can get a test on you so we can at least see where you are. Also, there's an issue regarding, they probably explained to you, might be a conflict with the attorney's office, with the public defender. So they're working on trying to get another attorney for your case, okay? All right. So what I'm gonna ask you to do is have a seat. We'll call your case back up and find out the answer to some of that, okay? All right. Thank you.
Your Honor.
Court calls case People versus Anthony Turner.
On behalf of people.
Stephanie Cannon on behalf of Mr. Turner. Mr. Turner, when you're up close, tell the judge your name, okay?
Anthony Turner.
Thank you, sir.
Okay, Mr. Turner. Your Honor, I am asking for a 2-week adjournment here. I am going to try very hard to work this out, short of preliminary exam. I do have paperwork here to have him screened for mental health court.
Felony?
Did you sign it?
I want to get out today.
I want Mr. Turner. I'm gonna ask the judge about bond, okay, but you need to sign this for me, okay? So here's the adjournment slip.
Today's the 12th,
Today's the 12th.
6/12.
Yes. Do you need to do anything with this referral?
Which court is that for?
Your Honor, this would be for 15.
15. All right.
So, Your Honor, we will provide this to you. Well, in the meantime, Your Honor, I'd like to ask for bond in this case.
Yeah, what I will do is I'll sign off on the referral sheet. I'll grant the adjournment July 3rd, 2025, 9 a.m.
7-3 at 9 a.m.
All right.
Your Honor, in the interim, I would like to ask for bond in this particular case for my client. At the time of this incident, my client was not being medicated. He is currently being medicated. He's receiving his shots. He's doing really, really well. He is asking if he could be tethered to the Leanta Center. Through this process, he winds up losing his house because he's not there anymore. And so he would like to get out, Your Honor. He's going to come back to court. He's not a threat. He doesn't have a threatening background. His history is not one of threatening behavior, and he'll appear whenever we tell him to appear, correct? He has a phone that does, well, it was working prior to going in. He'll get it turned back on as soon as he can. He is asking the court for the opportunity to be released.
Can I tether to the Leanta Center?
It's my understanding that you can, yes.
Yeah.
Are you?
I don't know if they do that.
Your Honor, I'll look into it to see if that's possible. If it is possible, I'll work with Attorney Childers to see if we can stipulate to it, if the court is inclined to consider.
Well, I'll take a look at it, but I've not heard of that before, so.
Okay.
I mean, I may have missed it. Given that, and until you check into that, I'm gonna deny the request for bond. I'll leave his bond. And if you find out additional information,
Thank you, Your Honor.
right?
My mailing address.
July
I'm
3rd.
gonna come talk to you in a second, Mr. Turner, okay?
That's fine. That's fine. They're gonna, yeah. Tell them. We're trying to get our social security straight. At the latest August, so she'll have the bill. Court calls case People versus Lena Harbali.
APA Richmond, deputy for the people.
Assistant Public Defender Hannah Apple. You have Ms. Harbali.
Judge, we received information yesterday that she was accepted into the mental health treatment court in 15th District.
Okay.
I know that APA was reviewing some information. There's been an initial offer extended I don't know if she needs more.
Ms. Apple and I discussed before the court started today, actually a while ago, Ms. Harbali has a new case that occurred after arraignment on this one. That case has been charged. It is a misdemeanor in 15th District Court. She also has 2 other warrants. What we discussed was the fact that I needed to finalize the offer, given that new information, and whether or not the offer would include an agreement not to authorize those other 2. So I needed a bit more time. If they want to move forward today with the plea, I can get the plea form together, but I obviously don't have it right now to discuss some of those other cases. So
Are the other cases felonies or misdemeanor?
it would most likely be misdemeanor
In 15?
in the 15.
Yes.
All the 15.
So they just sweep those off anyway.
Correct. I mean, that would be the assumption. This was all kind of prior to Ms. Harbali getting treatment she needs and those things are being assessed by the treatment court.
But she has been accepted.
She has been accepted. Court received notice yesterday.
Do they have the plea worked out? I'd like to get her on the move, but she.
My understanding, it was going to be to the misdemeanor as charged on this case. I think it's count 3, but I was waiting for that formally. I have advice of rights and sentencing waiver signed.
All right, well, why don't you guys, and I'll take the plea today if you guys get the paperwork and everything together. That way she can move on.
Yeah, I'd love to get it
Okay.
moved on if we
Then
could,
I'll
if the court will
pass
pass it
Guys
briefly.
work- Yeah.
Okay, all right. Just take a seat and we'll get it.
Court calls the case People versus Thomas Vasher.
Ashley Lonnie for the people.
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Vasher, who is approaching. Can you please say your name for the record?
Thomas Vasher.
Thank you, Mr. Vasher.
There are defense counsel has requested a misdemeanor offer from me. I do think we're going to be able to do that. I want to discuss it with the victim, so I'm requesting a little bit more time to do that. 1 week should be sufficient, Your Honor. Or I guess 5 days. rather.
Well, it's gonna have to be the 17th or the 26th.
17 would be great, Your Honor, since he is in custody. Thank you so much.
Second, sir.
Probable cause conference, June 17th, 2025, 9 a.m. Bond continued.
Patrick, can I please address bond, Your Honor? Yes. And also here's a green sheet for Mr. Vasher. Mr. Vasher would like me to ask for a personal reconnaissance bond today. He has been doing work with Home and New Vision consistently. He does have great support from his church community and his partner. He's actually going to be attending Full Sail University, which is a university with an online program that allows him to do programming in digital art, such as gaming and etc. He is part of a program called Launchbox that provides the technology required for this course. However, he has to go pick up that technology, and he only has approximately 4 days to be able to do that. I do understand he has no other holds in his other case, in his, any other holds. He does have a bond in another case in 14B. However, that bond is to be converted to a PR bond if he is released on this case. So I'll be asking for a PR bond.
Go ahead.
So I'll be asking for a bond.
Are you sure that's what's supposed to happen?
So that is my understanding.
Yes. What do you mean that's your understanding? Counsel, who'd you hear it from?
Mr.
Your
Batcher.
client?
Yes.
Yeah. Motion for bond reduction is denied at this time. After we have all of the information, I'll revisit it on the 17th, but if necessary. Thank you. Court calls the case People versus Fabrienne Hosmer.
Pass the line for the people.
And I'm actually have Mrs. Hosmer, who should be appearing via Zoom. Ms. Hosmer, if you could say your name for the record.
Fabrienne Hosmer.
Thank you.
Your Honor, we request an adjournment in this matter.
Probable cause conference will be adjourned 26, 2025, 9 a.m. Bond continued.
Thank you. We'll be in touch, Ms. Hosmer.
Thank you. Have a good day, Your Honor.
All right, take care. Court does call the case People versus Todd Reeberg.
Assistant Public Defender Jay Bellinger on behalf of, but not with Mr. Reeberg, Your Honor.
He's in Zoom.
Oh, I'm sorry, Your Honor. I did not know that he was in custody.
Your intern did. No, I'm kidding.
I wasn't aware that he was in custody, Your Honor. I understand that there's a circuit court violation. We did make every attempt to obviously get a hold of him, but I am not prepared today for his case. So I would ask to put this over for a week if possible so that I can talk to him.
I can do the 17th.
Okay. And Mr.
I'll need green sheets, please.
I will fill one out in short order.
17th, 2025, 9 a.m.
Thank you. Is he in Washington?
I will continue.
Thank you. I'll be by to talk to you, Mr. Reeberg.
Thank you. Sure. Let's call the case People versus Christopher Nunley.
Student attorney Kara Rosengren under supervision of APD Hannah Apple, Your Honor. Your Honor, we're requesting an adjournment as Mr. Nunley has been released to MDOT custody, and we're not sure where he's going to be housed at this time.
So, what do you mean he's being?
He has been released.
On the 10th.
No, let her.
Okay.
What, does she know? Does she know, or is it going to be a long story?
No, it's not a long story.
Okay, so I'll let her do it. Go ahead.
I know that he has been released to MDOT custody, and we are not sure. Yeah, we're MDOC. We're not sure where he's
Department of
been
Transportation.
housed.
He's on the highway.
Very quickly.
So what are you trying to tell me?
That he's
Do you
currently,
know what you're trying to tell me?
not exactly.
Did Miss Apple only give you half the information and then send you up?
That's probably my bad, Your Honor. So,
Oh,
yeah.
How's that sword feel that you just fell on?
I
Go ahead.
didn't ask for more information. I took the information to heart, and I probably should have clarified further.
That's great. You know, everybody's intern protects their supervising attorney except for villagers. So,
He didn't even hear you.
I know he didn't. You want an adjournment?
Yes, Your Honor.
Any objection from the people?
No, Your Honor.
Probable cause conference will be adjourned June 26, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Yes.
That's fair.
Is he here?
Yes.
Okay. Okay. Is he coming down?
He is coming back.
Okay. She has not. So, but we could send her over.
You can, yes.
On Miss Hall's case?
Yes, Your Honor.
Miss Hall, why don't you go over to community corrections? They're gonna give you a test, okay? They're waiting for you over there. And we have an attorney, Mr. Kittlewald's on his way back.
Very good, Your Honor.
So I'll let you hold Hall.
Oh, and that's the.
That's the plea, so I can't make it until I come back, so.
He's in the hospital. This is Spanish interpreter.
All right, court does call the case People versus James Lee Harmon.
Thank you, recommend nothing for the people.
Karen Badish on behalf of Mr. Harbin.
We have information that he's in the hospital.
Yes, Your Honor.
All right.
We are going to be asking for an adjournment because he's hospitalized. I have not had contact with him, and we have requested the 911 call, which the prosecutor's office is.
Probable cause conference will be set for July 3rd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
On the prosecutor at your trial, you're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
Yes, sir.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yep.
You could also waive your right to a jury trial, but maintain all the other rights we've discussed. You could try your case to the court. I too would have to be convinced of your guilt beyond a reasonable doubt, or would be required to find you not guilty. Do you understand that?
Yes, sir.
Do you believe you understand each of these rights we've discussed?
Yes, sir.
Do you understand that when you enter a plea of guilty, you'll be waiving all these rights? We will not have a trial.
Yes, sir.
That's how you want to proceed?
Yes, sir.
Okay, Ms. Tranter.
Your Honor, on or about April 10th, 2024, Warren County, State of Ohio, the defendant did knowingly obtain, possess, or use a scheduled controlled substance, specifically methamphetamine, Schedule 2, in an amount of 0.3508 grams.
Mr. Clark, anything on those facts?
Just that we would recommend and request the court to follow the joint recommendation for 6 months.
Okay. Mr. Hall, did you hear the statement that she read?
Yes, sir.
Do you admit and acknowledge what she said is true?
Yes, sir.
And again, you understand all the rights you're giving up entering a plea of guilty, the rights we discussed?
Yes, sir.
What is your plea?
Guilty.
The court will make a finding then that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we've discussed, and the court will accept your plea of guilty, and based upon the statement of facts of your plea, I will find you guilty. Ms. Tranter, anything else?
Nothing further.
Mr. Clark, anything else?
Nothing further, Your Honor.
Mr. Hall, is there anything you want to say before I sentence you, sir?
No, I just wanted to make sure because I'm under Reagan Tokes, right? And by getting this, they already sent me a paper in the mail stating that I would be receiving time for this. So this is going to be like double jeopardy for me.
Well, it's not double jeopardy. I understand what you're saying, but it's not double jeopardy. So what happens is What's the Reagan-Tokes charge?
For drug trafficking.
And what sentence did you receive for that charge?
I received 8 to 10 years.
Okay, so only one of those was a Reagan-Tokes, so it must have been a 2-year, so you got a 4 to 6 on one of your counts, and then he ran some things consecutive, correct? Okay, so you're on a 10 to 12.
And they served my mandatory time at the back end.
Well, your mandatory time goes at the front end, because your Reagan-Tokes time comes at the end.
Yeah, they did my mandatory.
When's the 10 years up?
10 years is up, 10 years is up in 30.
So in 2030 is when you finish your minimum term sentence.
No, that's the maximum. I leave in 28 right now.
I thought you said you received 10 to 12.
No.
8 to 10. I'm sorry, okay. So when's your 8 years up?
I already received one violation, so I got an additional year, so it's up in December 27, 28.
So you would have been out next year on the 8?
I would have been out for 27.
Okay, so what's happening then is this, what I'm gonna, let me sentence you, then I'll explain it, okay? I'll try to explain it to you, because I'm not really positive what they've done, but you got an 8 to 10. This is gonna be 6 months consecutive to that, to your.
And then they're gonna give me something too.
But not longer than your maximum term, they can't do that.
But I'm saying that any violation, so I'm getting time here, and then my parole's gonna give me time. So that's.
You're not on parole.
I see the parole board. They sent me.
But you're not on PRC right now.
They sent me a paper in the mail stating that I would see the parole board 30 days after my hearing.
Yeah.
And then they would give me more time there.
Yeah, but that has to do with the Reagan-Tokes. That has nothing to do with this case. Your violation of law in this case has basically triggered them to, they can't keep you past the maximum term of 10 years.
Not past 10 years, but they could give me them extra 2 years that's on the shelf.
Yeah, well, if you've already been added time onto that, they have to do it in increments, but yeah, you're right, they can. And that's one of the advisories, when I have someone plead to a Reagan-Tokes, I tell them that when you break the law in prison, you don't follow the rules in prison, the adult parole authority can add time to your sentence up to the maximum term. Yeah, you're right, but that's not double jeopardy.
I'm getting sentenced twice. I'm getting time
No,
twice.
because of your behavior, they're basically continuing your previous sentence. You're not being sentenced again for this. You're being punished because of your behavior on your previous Reagan-Tokes case. I understand what you're saying. Okay. Courts considered the statements made here today, the purposes and the principles of sentencing, the relevant seriousness and recidivism factors. The court has also considered the agreed recommended sentence of the parties and finds it to be an appropriate sentence. So I will order you to serve 6 months in prison on this sentence, that to be served consecutive to your current sentence. The court finds that a consecutive sentence is necessary to punish this defendant. It is not disproportionate to the conduct or danger posed by the defendant, and this offense occurred while the department was already incarcerated with the Department of Corrections. You have 0 days jail time credit on this 6 months. The court finds that you're indigent for the purpose of any fines, costs, or other financial sanctions. Now, you're also subject to this discretionary post-release control. Do you want me to go over that with you again?
Post-release control plus PRC?
PRC is post-release control. PRC is an acronym for post-release control. You want me to go over that with you again? We spoke about it just a minute ago.
No, I know I got 5 years already.
All right, this one's discretionary. It's 2 years discretionary. You understand that?
Yes, sir.
You want me to go over that with you again?
Cool.
Okay. There may be opportunities for you to receive up to 1 day per month for participating in certain education, vocation, or other programs sponsored by the Department of Corrections, because this is not mandatory time, okay?
Yeah.
Now, I know I'm going over things that you already know, but it's better for me to go over them again right now rather than have the Court of Appeals say, I should have talked to you about PRC time, and I didn't, so they send it back to me and drag you back over here. I don't want to do that.
Yeah.
I know you understand it, but I'm still required to say it on the record, okay?
Yes, sir.
You have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, that can all be provided to you at no cost. If you cannot afford an attorney, I will appoint one for you at no cost. You have any questions for me?
Yes, sir.
All right, good luck to you, sir.
Yes, sir.
Perfect. We'll wait for the paperwork to come in.
Perfect.
And we're all set. And I'll if the other party does appear, I'll let them know that we're just waiting for paperwork.
Okay, perfect. And I believe I'm back at 9:15. So if she does appear and she wants to wait around, I'll be back on.
Okay, great. All right, thank you.
Thank you. Have a good day.
Hi, good morning, Mr. Orozco. Can you hear me?
Good morning.
Hi, good morning, sir.
Good morning, Judge.
Hi, I have you checked in for your 9 a.m. hearing. The other party's not here yet. So you could just mute and turn your camera on and when everyone, or off, and when everyone gets here, I'll call it. Okay? But I've got you checked in.
Thank you.
Thank you. Hi, good morning, Ms. Magoon. Can you hear me?
Yes.
All right, I have you checked in. Your hearing set at 9. I don't have opposing counsel here yet for portfolio. So I have you checked in. You're here. You could just mute or turn your camera off and just sit tight with us. And as soon as we get everyone here, we'll call it, okay?
All right, sounds good.
All right, great. Ms. Malton, can I put these in?
following individuals failed to appear for court on June 11th, 2025, and show causes or bench warrants will issue. Ryan Adkins, Freeman Armstead, Brandon Blackshire, Cargo Force, David DeLong, Ramon Felix, F.J. Carrier, Nasia Hendon, Daryl Browder, Timothy Crane, Karen Ruff, Kelsey Hootie, James Salone, Johanna Ackerman, Phyllis Riley, Park Avenue Acquisitions, Robert Marhog, James Partners LLC, Betty Smith, Fidel Gaethie, Judith Lucas, Raymond O'Neill, Byron Moore, Devontae O'Rourke, Dominic Rambo, Christopher Smith, Dean Thompson, Michaela Turner, and that's it. Mr. Clark and Mr. Duquette, should I bring Ms. Houston back out?
Yes, yeah, we're all set. We have a consent judgment.
Hopefully we can get her out of the breakout room.
All right, Miss Houston, you're back with us. Officer Frisky, can you?
Hello?
Yep, Miss Houston, never mind.
Yes.
All right, we're on record on 24015380. I have counsel for Capital One and Miss Houston present. Miss Houston, can you turn your camera on?
Sure. Okay.
All right. Counsel, you indicated that after entering a breakout room, the two of you had, or the three of you have made, come to an agreement. Can you tell me the terms of that agreement, please?
Yeah, so we came to a consent judgment, Your Honor, in damages of the amount of $3,730.97, costs of $190.
Can you say that 3730?
3730.97, Your Honor.
Thank you. Okay.
And court costs of $194.10 for a total judgment amount of $3,925.07.
Okay. Is there a payment arrangement on that judgment?
Yes, Your Honor. We've agreed to a monthly payment of $80.
All right, Miss Houston, does that all sound accurate to you?
It does.
Okay, so the total amount of the judgment is, it's a consent judgment, $3,925.07 with a monthly payment agreement of $80. When is the first payment due?
June 28th.
Okay, and the 28th of every month thereafter?
Yes.
All right, Miss Houston, did you give counsel permission to sign your name on that judgment?
Yes.
Or are they sending it to you to sign?
Oh, no, they're sending it to me to sign. They're going to email it to me.
Okay, and you've exchanged email information?
Yes.
Okay, then we'll just wait for the paperwork to come in, okay?
Okay, thank you.
And you're all set. Everyone have a good day.
You too. Thank you. Bye.
All right, the People versus Jacob Pittock. Mr. Pittock was due in court today at 8:31 for a bond violation. He has multiple offenses pending at this court, driving on suspended and operating while intoxicated, and possession of controlled substance. He's failed to appear for his hearing today, and an immediate warrant will issue. He's a flight risk. That goes with us. Good morning, Miss Carnegie.
Good morning, Your Honor. Apologies.
Hi, good. Oh, you're exactly on time. No apology needed. You're early according to lawyer time. Ma'am, I have both parties on your two cases are present today in the courtroom. I have Miss Magoon as well as Mr. Orozco. Both of these are pre-trials. So Miss Magoon, Mr. Orozco, I'm going to put you both in a breakout room. Okay, and Miss Carnegie will come and speak with each of you to see if any resolutions can be made, and then we'll come back up.
Has signed a stipulated dismissal with installment payments, which I filed via the MyFile system because I think that my company was trying to file it via paper because the 23rd District Court did make that shift over the past week. So I filed it via the MyFile system 2 days ago on the 10th, but it doesn't look like it's been reviewed yet. So
I have a stack right here of files that I received for my filing, so I'll get that signed today. Okay, and we'll get it out to you guys. So Miss Magoon on 0863, 25010863, you're free to go, ma'am, and I'll sign that judgment as soon as I receive it, okay?
Awesome, thank you.
Everything's already waiting for me, but we're all still learning this new system. And we're all set.
Thank you.
All right, thank you. Okay, and then Mr. Orozco, have the two of you had any discussions?
No,
we have not.
not at all.
Okay, I'm going to put the two of you in a breakout room and we'll see you back in just a few minutes, okay?
Okay, thank you.
Versus Juan Orozco Jr. Did the two of you have discussions and were they fruitful?
Yes, Your
Yes.
Honor.
All right, can you tell me, was a consent judgment agreed to?
Yes, Your Honor. We're going to do a settlement of $7,200 on this debt, and that's going to be paid at a rate of $100 a month on the 15th of each month, beginning on July 15th. So it'll be 72 payments of $100 a month, beginning on July 15th. I'm going to put it into a stipulated dismissal. We are not seeking costs or interest of any kind. This will just be a straight debt that Mr. Orozco can pay off as quickly as he's able to.
All right, that's great news. All right, Mr. Orozco, is that all accurate?
Yes, it is. And she had my permission to sign.
Ooh, look at you. You sat in court for a few minutes and you picked this up. Good. All right. Permission to sign. That's great. We'll just wait for the paperwork to come in then and we're all set.
All right, I'll file it via the electronic MyFile system. Thank you, Your Honor.
All right, thank you.
Thank you.
Have a great day.
Yep, you two have a good day.
You too. Thank you.
All right, and Mr. Begg, have you checked in on Christina Edwards? And Miss Edwards is here now, so.
Good morning.
All right, Miss Edwards, can you hear me?
Yes.
Good morning, ma'am. Let me grab this file. I have both parties present on 2401-597-5973 Synchrony Bank versus Christina Edwards. Counsel, can I get your appearance?
Good morning, Your Honor. J. Begg, P36820, appearing on behalf of the plaintiff.
All right, and Miss Edwards, can you tell me your first and last name, please?
Christina, last name Edwards.
All right, have the two of you had a chance to discuss this case at all?
No, I have not. When I got the court, the documents saying that I needed to be reporting or something, I just sent the letters saying that I wanted to resolve this, and that was really it.
Miss Edwards, this is normal. I always ask the same question. So what I'm going to do right now, I'll put you in a room with Mr. Begg, a breakout room, so the two of you can discuss this matter, and we'll see you back in just a few moments when you're ready, okay?
Okay, thank you so much.
All right.
All right, so you'll have to join the breakout room and then exit the breakout room when you're done.
Okay.
And Mr. Saloom, I have you checked in on Crystal Gibson.
$5.81. She's going to pay. We've resolved it. She's going to pay. We'll do a consent judgment of $2,575.81 to be payable at a rate of $225 a month. starting July 1st of 2025. Your Honor, I mean, we could exchange documents and sign and file, but it might be quicker just to do this under the 7-day rule.
All right, well, Miss Edwards, did you give him permission to sign your name on the judgment?
Agree
Or
to,
do you want to review it? You have a right to review it.
like, does that differ from like what he's saying? Like what he said is what we just agreed on, and I'm okay with that.
So he just put on record that you're entering into a consent judgment, so you're agreeing to this judgment in the amount of $2,575.81, and that you've agreed to a payment plan where you would pay $225 a month starting July 1st of 2025 and the 1st of every month thereafter.
That sounds great. I'm okay with that.
So it's on record. So the judgment, when it comes in, it will match what he put on record, or I won't sign it.
Okay.
Okay.
That sounds good.
So you're giving him permission to sign?
Yes, ma'am. He has permission to sign. Yes.
Okay.
I'll have, Your Honor, I'll have counsel of record prepared and sign it on her behalf. Okay.
Okay. All right. Then the two of you are all set, and just make those payments, Miss Edwards. Okay.
I sure enough will. Thank you so much, Your Honor. I really appreciate it.
Yep.
Thank
You two
you.
are all set. Have a good
great
day.
one.
You too.
Give me just a minute, counsel. Mr. Cox, are you with us? I have Mr. Peterson here.
I'm here, Your Honor.
Oh, all right, this is 240133115 Garner Properties and Management LLC versus Amarender Chinola. Can I get appearances?
Good morning, Judge Aaron Cox, appearing on behalf of the plaintiff.
You're muted, Mr. Peterson.
We go Don Peterson on behalf of the defendant.
Okay, and you're breaking up really bad, so you know. I just want to make sure I can hear you.
Okay, is this?
That's better. All right, so we had a motion filed. The motion was filed for a new trial. And also a motion for reconsideration on my ruling on, a motion here. So we're here. I've reviewed everything that was submitted. I reviewed the record as well on this case. And I'm just going to tell you, I do not believe that the motion for a new trial is proper. Obviously, there wasn't a trial. It was my decision was based on a motion. So motion for a new trial is denied because there was no trial. The motion was also brought under 2119 parent F. And this motion or this court rule specifically goes into motions for rehearing or reconsideration. And we had a motion that was filed timely. This court is not required to have oral argument on the motion. I reviewed everything in the file. There was no palpable error. This was a straight contractual dispute. I could make it determine on my motion without any testimony or anything other than the four corners of the documents. The plain language of the document contained the contractual terms that my ruling was based on. And I was able to make my decision based on the four corners of the document. There's no crying in contrast. Parties are bound by the terms. The terms were not ambiguous. It was a clear term, and whether or not the plaintiff, when the defendant indicated that he was selling the home, the fact the plaintiff did not say in an email, oh, okay, don't forget this term of the contract, doesn't mean that both parties aren't bound by the terms of the contract. That it was in the plain language. So the motion is denied in its entirety. I do believe the motion was frivolous. There were no new grounds that the motion was based on. Under the court rule, MCR 2.119 parent, strike that. 1.109 parent 6 and 7. I am granting sanctions for attorney fees for appearing at today's hearing. There is nothing that allows plaintiff to file a responsive pleading under the court rule for reconsideration. So I'm not granting that, but I'm granting $300 in attorney fees for appearing at today's hearing and otherwise having to review the pleading. And that's my ruling. One of you can submit an order to the court indicating as such.
Thank you, Your Honor. I'll get that order prepared and submitted by my file today.
All right, we're all set. Thank you.
Thank you, Judge.
Mr. Fay, good morning.
Good morning.
For Atkins, let me see.
There is a opposing case.
So you're here for JP Morgan?
Correct.
Mr. Fay, okay. I don't have any other attorneys in the waiting room right now. So we're just sitting tight. I'm going to take a 5-minute recess and give people time to show up for court, okay?
Okay, that works.
Thank you. filed by
and I
on us. All right, good morning, everyone. So this is who I have checked in right now, council. I have Mr. Saloom here on Discovery Bank, Mr. Fay here on JP Morgan Chase. I have 0257. Mr. Truba checked in for Jefferson Capital. And then I have Mr. Clark and Mr. Duquette checked in on Capital One. Let's see if we have any of the other parties here. I have 3 people in the waiting room. Oh, I've got another attorney. Good morning, Ms. Pelion.
Good morning.
What are you here on this morning?
I'm here in Atkins, I believe, and I apologize. I'm in my car. We lost power at my office this morning. So,
are you downriver?
No, I'm in Farmington Hills. So my husband just texted me that it came back, but I went to the Starbucks parking lot to make sure I could get a signal.
That's okay. Okay. What was the case? I'm just trying to find the case.
Yeah, no problem. Sorry, I'm just checking.
The JP Morgan Act.
Oh,
Thank you,
I
Greg.
love this. Okay, I have you. Do you two need a breakout room?
No, if you're
I don't think so. Yeah.
Letter 60 days discovery.
Okay, great. Give me 1 sec.
Sure.
Thanks.
Okay, so you're requesting discovery order.
Yes, please.
All right, for the record, this is 250118288 JP Morgan Chase versus William Adkins. Can I get appearances?
Good morning, Your Honor. Craig Fay, P81401 on behalf of plaintiff.
And good morning, Your Honor. Jennifer Palin, P80284 on behalf of defendant.
Okay. What's on a scheduling order? Then with 60 days discovery. Uh-oh. That takes us to August 14th. Discovery ends August 14th, 2025. All discovery motions must be filed prior to that date. Witness lists are to be exchanged by August 21st of 2025. Dispositive motions are to be filed by August 28th of 25. Answers to dispositive motions are to be filed by September 11th of 25. And, adjournments, agreements, stipulations must be done by tendering a signed stipulation of proposed order. And I will hear all dispositive motions at our final settlement conference, which is the next time I will see you absent discovery motions. And that will be on September 25th. And it'll be at 11 a.m. And we'll see you all back on that date.
Thank you.
Thank you. Take care.
All right, thank you. Mr. Bingham, good morning. Can you hear me? Good morning, Mr. Bingham.
Good morning, Your Honor.
Trying to see what you're here on. I've got you here with Capital One. Have the two of you had any discussions yet?
No.
Okay. So I'm going to put you in a breakout room so you can speak with Mr. Clark and Mr. Duquette and see if there's any resolutions, okay? And then I'll see you back in a few minutes.
All right.
So, Mr. Bingham, you'll see something asking you to enter a breakout room, join that breakout room, and when you're all done, you can come back out and just exit the breakout room, okay?
Okay.
All right, I have someone in the courtroom. It just says iPhone. Can you tell me your name? I have iPhone in the courtroom. You're unmuted. Can you hear me? Hi, there you are. Can you tell me your name, ma'am? Does she not have audio? I'm moving Mr. Duquette into room 2, and I'm moving Mr. Bingham into room 2. So Mr. Bingham, both of you should see something moving you to that room. Go ahead and join that. I have someone here. It just says iPhone. Ma'am.
Yes.
Can you tell me your first and last name?
Monica Cooper. Sorry, I couldn't hear.
Okay, we've got you now. All right. Do I have anyone here on Miss Cooper's case? Oh, that's you, LVNV.
Yep. Correct.
Your Honor, that's my file as well.
Wait, you both have this case?
I think
LVNV funding versus Monica Cooper?
there should be one for Jefferson Capital, Your Honor. This was adjourned. I think she had 2 cases in April.
Oh, she sure does. I see.
Yeah.
Mr. Truba, Mr. Fay. All right, Miss Cooper. We're here today for a review on these 2 files. So. All right, this is 25010257 and 25010309, and we have Jefferson Capital Systems versus Monica Cooper and LVNV Funding versus Monica Cooper. Can I get appearances?
Good morning, Your Honor. Brian Truba, appearing on behalf of the plaintiff, Jefferson Capital Systems, in case number 25010257 GC.
And then good morning, Your Honor. It's Craig Fay, appearing on behalf of LVNV Funding in case number 25010309.
Okay, and ma'am, can you tell me your name one more time?
Monica Cooper.
All right, so we were here and I have notes in both files saying that we were adjourning this out 30 days because Ms. Cooper was filing for bankruptcy. What's the status of that, ma'am?
So I have talked to a lawyer. In order to file for bankruptcy, I have to be caught up on my car payments, and I'm not. So once I'm caught up on my car payments, then I can put the paperwork and file, but I can't. I've been paying on my car, but I'm still not caught up.
Okay,
Because
well,
sorry.
If you're in bankruptcy, that automatically stays these proceedings, ma'am. But if you're not in bankruptcy, I'm not going to stay proceedings on these cases if the bankruptcy's not been filed. That would be improper. So we can set a scheduling order on each of these cases. And hopefully, if she's going to file, she'll file during the discovery phase. I doubt you need that much discovery on these cases, but that would potentially give her some time if she's filing, but also allow the cases to move forward if she's not. Anyone have any thoughts or concerns with proceeding in that way?
Judge, I'm in agreement with that. If we could have 90 days discovery, hopefully she can catch up with her car payment and take care of whatever bankruptcy business she needs to take care of.
All right. So I am going to, I normally don't give 90 days for discovery, but realistically, I don't see any reason to push this case through if that is where it's heading. So I will grant 30 days or 90 days. So discovery ends on September 11th of 25.
What is discovery, if I may ask?
Ma'am, so all it is, Ms. Cooper, is an opportunity for the parties to exchange documents, okay, or answer questions. There will be no request to admit.
Okay.
So they can't send you questions saying admit this, admit that, but they can send you interrogatories regarding your financial status, regarding the debt. You can send them questions as well. And everybody has until September 11th to do that. All discovery motions must be filed prior to that date. Witness lists. So if you have witnesses that you're going to call at a hearing, you have to file a list with the court of the names of those witnesses. And those are to be filed by September 25th of 25. Any dispositive motions, so motions that could get rid of the case. If they file a motion and say there's no issue of material fact that would necessitate a trial, they can file those motions at the court, and I would hear those motions to determine whether or not the case should proceed to trial. Those motions are also due September 25th of 25. And obviously, Ms. Cooper, if you have a legitimate defense and show these aren't your debts or whatever the case might be, you also could file that motion. Okay?
Okay.
If you receive these motions, you're to answer them. And the motions are to be answered by October 9th of 25. Any and all adjournments, agreements, stipulations must be done by tendering a signed stipulation and proposed order. So if you come to an agreement, Ms. Cooper, that means that both parties have to sign it and send it into the court for my signature.
Okay.
And the next time I will see any of you will be at the settlement conference on October 23rd of 25.
Okay.
At 11 a.m. And that will be the final settlement conference. It will also be the date that I hear any motions for summary disposition or other dispositive motions, okay?
Okay.
Anything else that needs to be put on record?
All set, Your Honor. Thank you.
All right, we're all set for the day then, and we'll send you out that scheduling order.
Thank you.
Day.
And Ms. Cooper, you're free to go. Give me 1 second, everyone else. All right, I see I have Mr. First on Crystal Gibson. Do I have counsel on this?
Yes, Your Honor, I represent the plaintiff.
All right, well, this is 240147006, Discovery Bank versus Crystal Gibson.
Yes, Your Honor, good morning. For the record, Williams, 4147.
You're breaking up really bad.
Oh, I'm sorry. Let me try that. William Saloom appearing on behalf of plaintiff in this matter. P41.
All right. I'm quiet. Tell me. What's the P number?
41487.
All right, so this matter was scheduled at 9:30 a.m. It's 10:05. Ms. Gibson's not appeared in person, nor has she appeared via Zoom. I do have that she was served. She filed an answer with the court. She was notified of today's court date. I see she was served through alternate service, but I don't think there's a real doubt as to whether or not she received service because she did come in and file an answer. And she's not here today, counsel.
Your Honor, if it pleases the court, I would ask full defendant in default for failure to appear, and we would submit proposed judgment by default under the 7-day rule.
All right, can you tell me what the total amount would be?
Yes, Judge. The damage amount is $398.01. We have court costs of
$3,398.01.
Correct. And then there's court costs of $179.05, would be the filing fee, the motion fee, and the service fee. For a total judgment amount, we're asking for $3,577.06.
Okay, and I would also note that this is an account stated, so there's no for a hearing on damages. So default's entered.
Thank you, Your Honor. And should we judgment under the 7-day rule?
You can submit under the 7-day rule.
Thank you.
All right, Mr. Bingham, I have you back out here. Where is Mr. Bingham's file? There you are. This is 2501-0869 GC Capital One versus Walter Bingham. We have all parties back present in the courtroom. Did you have discussions and were they fruitful?
Yes, Your Honor. We were able to come to a resolution in the form of consent judgment.
All right. Can you tell me the terms?
Yes. That consists of damages of $1,682.80.
I'm sorry, how 80 cents?
Yes, ma'am. Or Your Honor.
Okay.
And court costs of $120.20 for a total judgment amount of $1,803.00.
All right. And Mr. Bingham, is that what you agreed to?
Yes, ma'am.
All right. And did the two of you come up with any sort of payment arrangement?
Yes, Your Honor. We agreed to $50 a month beginning on July 3rd.
And then the 3rd of every month thereafter?
Yes, Your Honor.
Does that all sound accurate to you, Mr. Bingham?
Yes, ma'am.
All right. And did you give plaintiff's counsel permission to sign your name on that judgment, or are they sending it to you for review?
They're gonna send it for a review.
All right. Did you exchange email addresses or?
Yes.
All right. So you've agreed to allow them to send you that consent judgment for review and signature via email?
Yes, ma'am.
All right. Okay, then we'll wait for the judgment to come in and we're all set.
Thank you, Your Honor. Thank you, Your Honor.
All right. And we're all set, Mr. Bingham. Thank you. Have a good day.
You too. Thank you.
Okay.
That's what I was gonna request today, was if the court would set aside the default judgment, we can just enter the consent judgment we have.
All right, motion to set aside default judgment granted and the consent judgment will enter upon receipt.
Great, thank you, Your Honor.
All right, you're all set, thank you.
Have a good day.
You too. Okay. One second. Here to do anything on this. I mean, I don't have any. I mean, I don't have anybody here to make any sort of decisions one way or another. Everybody received notice. I'm just gonna adjourn it. And we'll send out notice of a new date, and if no.
And just so that I am placed in a
Yes, she had
an
no place to go,
unfortunate
right.
circumstance, and it's not as though what she was doing was not trying to comply. She went there, but she just didn't have funds to do anything. So she'll have a bill coming out of it. You understand that, Ms. Hall, right? Yep, they'll be charging you, but I've explained to them the circumstances. I've explained to community corrections.
Because she said when I leave here, I have to go back.
Pardon?
She said when I leave here, I have to go back.
Yeah, you have to go back over so they can get you enrolled. And then it's once a month testing. The test that you took today is going to be your June test.
Okay.
So you won't have to test again for next month. I think your previous counsel had told me you may have something with your SSI straightened out by August.
Well,
She said it says July 8th, she has an appointment.
Okay,
So
so if
both-
she gets it straightened out, that's fine, because then the funds will be there for her to have that once a month.
Yes, we
But
will.
what I want you to do is, I don't want you to worry about that right now. We kind of took care of that. I want you to just make sure you get over there and you task. Okay?
Yes,
The
sir.
other thing is, I don't want you using. You hear me?
I won't.
Okay.
I'm just depressed,
What do you say?
just depressed.
I
I'm
understand.
7 months with no income, living in the street, and somebody else is spending my money. And nobody's doing nothing about it.
Okay. All right. Well, this didn't turn out bad for you today, right?
Thank you.
You're welcome. All right. And I have to thank you for not getting, if I were in that situation, I think I would have been screaming and yelling at anybody that talked to me.
Well, I actually was scared.
Huh?
I actually was scared.
Of me?
Yeah.
You were scared of me?
Yeah.
Judge, I told you.
Little me?
Judge, I've told her you're a very kind and considerate judge. You're the type of guy that people want to go in front of when they've made a mistake.
Mr. Kilowald, you are such a liar. We were doing well until you started that. All right. Let me adjourn this out a couple weeks for you, okay?
Okay.
All right, so I'm gonna adjourn it out to June
My
20th.
birthday's not my birthday. It's the 26th of this month. I was hoping I'd not be in jail.
Hold it, your birthday's the 26th?
Yeah.
Okay, then you're gonna have to come see me on your birthday. Will that be okay?
Yeah.
Okay.
With June 26th?
Yeah.
You're coming back here
Yeah.
for your birthday?
Yeah.
You should not do that, you know?
You want me to get, you know what?
I'm just kidding.
No.
June 26th, thank you, Your Honor.
July 3rd.
Oh, July 3rd, okay.
She can do something else for her birthday. July 3rd, 2025, 9 a.m. Okay. And
Judge,
Bond will
will
continue.
that
You
ti-
get over to community corrections.
Will that time stick? The only reason I ask is she has no phone, no means of,
It likely, well, it may only because you will probably have people in custody.
okay,
So that it's likely to be right around.
so we can set it for 9 a.m.?
Yeah, but I don't, you know how it works with our blocks.
Well, it's just, it's,
No, I hear you.
okay. Okay, thank you
Okay.
very much for your.
Ms. Hall, happy birthday,
Thank you.
since I won't see you.
Thank you.
All right.
Thanks, Judge.
Court calls the case of the people versus Lena Harbali.
If you ever to me, the Assistant Public Defender, Hannah Apple, appearing on behalf of Ms. Harbali. Harbali, please state your name for the record. Lena Harbali.
I have before me a plea form that indicates. I don't know what this means. She's just pleading to the I didn't need a plea form. She's pleading to the stated counts 3 through 5.
Correct.
And 1 and 2 are going to be dismissed, and she's pleading guilty.
Yes.
Solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Lower your hand and state your name again.
Lena Harbali.
All right. Sir Harbali, it's this court's understanding that you're going to be pleading guilty to 3 counts of malicious destruction of a building. Is that correct?
Yes.
All right. 2 of those counts 3 and 4, are malicious destruction of a building 200 to 1,000. Those are misdemeanors punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased 3 times the value of the damage or injury to the building. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes.
All right. And count 5, the malicious destruction of a building is less than 200, which is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. That fine could be increased to 3 times the value of the property destroyed or otherwise injured. If it's greater than $500, that becomes a maximum fine. You understand that?
Yes.
All right. Understanding all of that, you still wish to plead guilty. I do have to advise you of one other thing. While I'm taking your plea, I would not be your sentencing judge. You would be sentenced before Judge Perry in the 15th District Court. You understand that?
Yes.
All right.
Sorry, Judge. It would be Judge Valvo, correct, with the mental health?
It would be, but the case assignment that they have, it will go to Perry, but then
They move it.
because she's there, well, then I think they do
Okay.
that there.
Okay. The court 15 sent me dates that they like asked from mental health court, but I don't know if I will follow up and change it later.
So they sent you dates that
6/18 or 7/2 in front of, for mental health court.
Okay. Then
Sorry.
what I'll do is this could get messed up, but I'll make it Valvo.
Okay.
In any event, you'll be sentenced in front of somebody other than me. Okay, all right. And understanding all of that, do you still wish to plead guilty to these charges?
I do.
All right. To the charge of malicious destruction of a building 200 to 1,000 as contained in count 3, how do you plead?
Guilty.
To that same charge as contained in count 4, how do you plead?
Guilty.
To the charge of malicious destruction of a building less than 200 as contained in count 5, how do you plead?
Guilty.
You understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
All right, look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Has anybody threatened you or coerced you in any way?
No.
Get you to plead? Counsel, are you aware of any pleas or promises, threats, or inducements that are causing this plea other than what's been stated here today on the record?
No, Judge.
You're doing this voluntarily
Yes, sir.
and of your own free will.
Yep.
Okay. And because you believe that you're guilty of these offenses?
I was.
Yes.
Yes.
All right. On the date or between the dates of March 19, 2025 and March 24, 2025, at the location of 312 West Huron Street, City of Ann Arbor, Washtenaw County, State of Michigan. What do you do? Well, actually, it's going to be different buildings. It's actually 304 South Ashley, 300 South Ashley, and 308 South Ashley. At least as is contained in the report here. What do you do to those buildings that makes you think that you're guilty of these offenses?
Judge, may I have one here?
Yes, please.
Thank you. Ms. Harbali, on the locations listed on those dates and times in March of this year, did you go to the Fleetwood Diner, the diner next door, and then a retention wall there? And did you mark those with graffiti?
Yes.
Okay. And you did not have permission to graffiti those locations and those buildings and that property?
No.
Okay. And would you agree that the damage that you caused from the graffiti has a value of $200 to $1,000 for each of at the Fleetwood Diner and the diner next door to it?
Yes.
Okay. And as for the retention wall, would you agree the damage was less than $200?
Yes.
Defense is satisfied. I think covered everything.
Ma'am, I do have to advise you that if the judge, the sentencing judge, Judge Valvo, does not follow any prosecutor sentence regarding recommendation, you're not entitled to withdraw your plea. The court further has to advise you that if between the date that I accept your plea today and the time of your sentencing, that if you commit some type of misconduct, that you're also not entitled to withdraw your plea unless allowed by the court for good cause. You understand that, ma'am?
Yes.
All right. Has the court complied with the court rule? Would it be proper to accept this defendant's plea?
Defense is satisfied.
Court will accept the defendant's pleas of guilty. 2 counts 3, 4, and 5. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter, and what was the date you had? I'll just do that.
I think based on the interview, July 2nd would be,
July 2nd?
yes, that was the date that was given.
July 2nd, 2025. It's at 9 a.m.
They didn't provide a time. We'll say 9 a.m. and I'll confirm.
All right, 9 a.m. and that's before Judge Falvo. I'll just mark on here, mental health court. You see, I'm changing it. All right, your bond will continue. Thank you. Good luck to you.
Thank you.
Court calls the case, People versus Valerie Robinson.
Good afternoon, Your Honor. Edward Lucas on behalf of Valerie Robinson.
She is,
Your Honor. No.
Valerie Robinson?
Yes.
Okay. All right, state your name, please.
Valerie Robinson.
All right. Okay, what are we doing?
I'm asking for a preliminary examination.
All discovery is complete.
To my knowledge.
People would have their witnesses available the 24th.
We'll do our best, Your Honor.
Preliminary examination in person will be set June 24th, 2025, 9 a.m. That's before Judge Fleischer. Bond will continue.
No,
Thank you, Ms. Robinson.
Tell them that you handicapped, you can't go. They don't know you handicapped.
I told him.
How you gonna get there?
I told him. Hello?
Hello?
Yes, I had a stroke in October. I can't get to the courthouse.
Okay.
No worries. I was aware, and she indicated that she could get to the courthouse in a wheelchair.
If I can get it right, there's if, keyword if.
She ain't got nobody with transportation.
I just got lucky that day.
I can be in communication with the prosecutor's office if adjournment's needed, but I think that's enough time to
figure it out.
Yep.
Okay, I'm going to leave it set. Talk to your attorney about that and see how we're going to get that worked around. Okay.
Okay.
All right. Thank you, ma'am.
Thank you.
Mm-hmm.
Court does call the case. People versus James Taylor.
Andrew Jules, Edward Lucas on behalf of James Taylor.
Is he on?
He is not on, Your Honor.
Okay. So you just walk off. Okay. Well, thanks for letting me know. It's really nice. You guys go ahead and have your conversation. I'll just sit here and wait.
I'll let Mr. Curtis play.
Everything that he put. Okay. All right. I don't know why he had to whisper it to you. We all. he was determined to have a conversation with you, though.
I was, Your Honor. Actually, I'm asking for an adjournment today. I'm trying to find out what actually is going on. He is in the hospital, and I believe he's in Spera Hospital up in Lansing. And
you think he is, or you?
I have received this information from a family member, and he may be being detained there while he's.
I'll need a green sheet, and I'll adjourn it out without objection.
That's fine, Your Honor. And I was Mr. Lucas, when he was whispering to me, also mentioned that he may be under the detention or supervision of the Ingham County Jail. So I would just ask if Mr. Lucas finds out that he is actively housed at the Ingham County Jail to let me know so I can prepare a writ.
Thank you for sharing.
No problem.
I was going to show.
I was going to share it. No, you weren't going to share that. You made something. He's in the hospital, and just weren't going to mention that part.
Trying to use some positive facts and get an adjournment. I just got discovered.
I'll let it go this time.
Thank you. Have a great day.
Yes. Court calls the case. People versus Sarano Johnson.
Stephanie Can on behalf of Mr. Johnson. Mr. Johnson, when you're at the lectern, please state your name for the record.
Sarano Johnson.
Your Honor, we are requesting a two-week adjournment to do some negotiating on this particular matter.
All right. That objection, June 26, 2025, 9 a.m. as your invite indicates. Bond will continue. Thank you, sir.
Thank you so much, Your Honor.
I'll call you like I did before. Okay.
Of course. Court does call the case People versus Anthony Lafredo. What, did I surprise you or what?
Anna Mackey on behalf of Mr. Lafredo. Your Honor, I checked X jail and it looks like after he was released from Washington County, Jackson County ended up picking him up. So he's currently in that jail. So I'd ask this court for an adjournment, Your Honor.
You're not going to do a jerkus. Is there something else you can tell me?
No, sir.
All right. You think he's in Jackson?
I know he's in Jackson.
All right, I'll adjourn this out then. Probable cause conference, 26, 2025, 9 a.m.
Thank you, Your Honor.
Bond continue.
Thank you.
Court calls case People versus Dwight Miller.
Ashley Lonnie for the people.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Miller, who approaches your. Mr. Miller, can you please state your name for the record?
Dwight Miller.
Thank you.
And Your Honor, my belief is that my client does want to set this for preliminary examination. However, I am uncertain. He and I have had some conversations, and frankly, I believe he wants to make some statements to the court. I advise him against it, but at this point, I think he wants to talk.
So we're understanding this is a criminal matter, right?
It is.
Okay, so basically, man, it stemmed from a falsality. All this whole thing, I was falsely arrested, something I never did. I got a sworn affidavit.
Sir, I'm sure your counsel has advised you. I'm going to advise you to not say anything else about the subject matter of the case.
Okay.
If you'd like it set for preliminary examination.
I want to challenge jurisdiction.
You want to challenge jurisdiction?
Yes.
Of whom?
Y'all have a jurisdiction of a case that doesn't exist against me.
On what grounds?
What crime did I commit?
Pardon?
What crime did I commit?
Allege that you committed the crime.
I didn't commit that crime.
If you want to interrupt me, I'll answer your question. But if you want to keep interrupting me, I'm not going to play that way. I'll answer your question. You're accused of the crime of attempted or not attempted, but resisting and obstructing a police house.
So we all aware that this never transpired, right?
I am not aware of that.
Okay.
Is that all you have to say?
Mm-hmm. Yes, sir.
So, Your Honor, I would ask Mr. Miller. Mr. Miller, I'm not submitting frivolous motions.
Can I get my affidavit put in on the record, please?
Affidavit.
My affidavit of the incident that transpired.
Your affidavit of what?
The facts in the case. My statement of what happened. Can I get it on the record?
There will be an opportunity if you so choose, if this goes to a further proceeding, for you to put whatever evidence you want into the court. But this is not the time to do that.
Really? So when is the time to put the evidence in here?
If you want it set for a preliminary examination, you'll have that opportunity. And if it proceeds to trial, you'll also have that opportunity.
Right.
So once again, I'll ask, do you want to set this for preliminary examination, Mr. Miller?
Sure.
Thank you.
Not really.
See, do you want to set it for prelim or do you want an adjournment?
Preliminary examination.
Thank you.
To your knowledge, all discoveries.
To my knowledge, yes, Your Honor.
People have their witnesses available the 24th.
Yes.
We could try for that date, Your Honor, if possible. I might ask to go one. No, let's do that date. Thank you.
All right. Preliminary examination in person will be set June 24th, 2025, 9 a.m. That is before Judge Washington.
Thank you, Your Honor.
Thank you. And we'll
You want to get this camera? They will have it. I will make sure.
Court does call the case. People versus John Michael Nowak.
Alex, I'm on behalf of the people, Your Honor.
Oh, that was fun.
Kevin Dadish on behalf of Mr. Nowak, stepping in for Attorney of Record Chelsea Burgess. Standing for the record. Your Honor, we were going to be asking for a brief adjournment to continue plea negotiations with the prosecutor's office.
Without objection, probable cause conference, June 26, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
Also, talk to you.
Court calls the case. People versus Timothy Pennington.
Actually, for the people.
Afternoon, Your Honor, Hannah Mackey on behalf of Mr. Pennington, who should be appearing via Zoom. Nope, actually to my right, Your Honor.
But
Please state
apparently
your name.
left the other parts of his pants someplace else.
I'm sorry, do I need to wear pants?
Pardon?
Do I need to wear pants next time? Instead of shorts?
Yeah.
Okay, sorry.
Yeah, well, just bring the whole pant set. That's all I'd ask. Go ahead, Ms. Mackey.
Your Honor, we'd like to set this matter for preliminary examination and all discovery is complete as far as we are aware.
People have their witnesses available the 24th.
Checking right now, Your Honor. We'll try for that day. Thank you.
Preliminary examination in person, June 24th, 2025, 9 a.m. That is before Judge Fleischer. Bond will continue.
Thank you, Your Honor.
You didn't tell him to wear the whole pants? What?
I like the shorts. It's hot out. It needs to be comfortable.
Okay, so I'm going to assume your next client that walks up in shorts that you told them to do that. All right, that's what I'm going to assume. I'm not even going to ask a question. And then you know what's going to happen? Both of you are going to go, but I think they got bail money for you. What? What'd you say?
I said she's not in the union. We don't.
Wow. Guess that's a problem. You guys have not been friendly to each other. No, you really haven't. Where's my one intern that was throwing everybody? There you are. Throwing everybody under the bus. People of the state of Michigan versus John Riggs.
Ashley Lonnie for the people.
Mr. Riggs is Hannah Mackey on behalf of Mr. Riggs, who is appearing via Zoom. Mr. Riggs, please state your name.
John Riggs.
Probably got shorts on. Go ahead.
Your Honor, we are requesting an adjournment in this matter. We are awaiting sobriety court to get back to us about his eligibility.
Start to Sobriety court eligibility?
Yes, Your Honor.
Have you been interviewed by them yet, sir?
No, I haven't.
You haven't? Okay.
If Your Honor, if the court recalls, I think we talked about this last time, he was in sobriety court and then picked up this new OWI, so it was just a question of whether or not he's gonna be able to come in on the new case.
Oh,
So that's kind of like, I think what's holding us up right now, if I recall correctly.
all right. Let me adjourn it then, Mr. Riggs, to July 3rd, 2025, 9 a.m.
Thank you, Your Honor.
Try to get everything straightened out. All right, sir?
Thank you. Yes, sir.
All right, thank you. On, continue. Court does call the case, People versus Alexa Russian. Okay.
And Assistant Public Defender Nick Bukovich on behalf of Ms. Russian, who should be appearing via Zoom.
I'm here. Sorry, I had to figure out how to. I'm sorry. I'm here.
It's okay.
I had to figure out how to cut it on.
Can you please state your name for the record, Ms. Russian?
Sorry, Alexa Russian.
All right, thank you.
At this time, Your Honor, we will be requesting a brief adjournment to allow for more time of negotiations with the people.
June 26, 2025, 9 a.m. Bond continue.
Thank you.
All right, thank you, Ms. Russian.
Thank you, Your Honor.
Oh.
What, she didn't have her green sheet ready? No, get it from her. I'll take the time and just diddle it. Sign. You're welcome. Court does call the case, People versus Derek Shipman.
Brian Bowley on behalf of Mr. Shipman, Your Honor.
Oh, Derek.
State your name for the record, please.
Derek Shipman.
Oh, sorry.
Derek Shipman.
Thank you, sir.
Judge, I'm asking for an adjournment. Ms. McDuffie and I think have resolved the issue with respect to the video discovery, and I just need to get it and watch it.
Okay, good. Probable cause conference, June 26, 2025, 9 a.m. Bond continue.
But I.
Thank you, sir.
Thanks, Judge.
It's not that uncomfortable. See, he's got all clothes on and he's just fine, Mackie. Court calls the case, People versus Romeo Serba.
Andrew Childers appearing on behalf of people.
Emma Dadash on behalf of Mr. Serbo. Romeo, can you say your name for the record?
Romeo Serbo.
Your Honor, we are going to be setting this for preliminary exam.
All discovery is complete.
Yes, Your Honor.
People have their witnesses available the 24th. Preliminary examination in person, June 24th, 2025, 9 a.m. That is before Judge Washington. Bond will continue.
Thank you, Your Honor.
Thank you.
Thank you.
Case of the People versus Kevin Stevens.
Andrew Childers appearing on behalf of people.
Stephanie Cannon on behalf of Mr. Stevenson, who is approaching. Am I right? Mr. Stevenson, could you please state your name for the record?
Kevin Deshawn Stevenson.
And yeah, hands.
Wait.
And Your Honor, we would,
Why are you doing that?
What is that? What is that?
we would have it say, he just came in.
He's
Kevin Stevenson. We would
I can't help that. Not my fault. Don't blame me.
We're just asking for it to be set for PE.
What happens to the little person?
Oh, he's back there.
He is so behaved. Oh my gosh.
Excuse me?
He is so behaved.
Okay.
He's-
Sure.
We're gonna set it for PE, Your Honor.
Okay. Cannon, you are not right. People have their witnesses available the 24th.
That's fine.
Preliminary examination in person will be set June 24th, 2025, 9 a.m. That is before Judge Fresh Hour.
Was it a?
It'll be here at 9 a.m.
Oh. Thank you.
Thank you, sir. Court calls the case, People versus Colin Vandermeer.
That's a lot of good people.
An attorney, Daryl Frederick, under the supervision of APD Hannah Apple on behalf of Mr. Vandermoot, who should be appearing by Zoom.
So,
That's unfortunate, Your Honor.
Miss Apple? Why are you looking at Miss Apple? Because she told you he'd be here via Zoom, didn't she? And now, you know what happens? She's like slinks up there and she's gonna ask me, can you pass it? And can I call him?
I wasn't gonna ask that.
Okay, go for it. Go
I
ahead.
was gonna ask for an adjournment. Mr. Vandermeer is in a behavioral inpatient center. He's been appearing via Zoom from Turning Leaf. I always communicate with the case manager and send the Zoom link this time. I don't know why they're not on today, but considering all prior appearances, I would ask for consideration of an adjournment. We're waiting for him to go to the forensic center. It's been months and I don't have an update. Our office did try to find an alternative, but unfortunately that was not successful.
Got it.
So now we wait.
Any objection to the adjournment from the people?
No, Your Honor.
Probable cause conference will be adjourned July 3rd, 2025. 9 a.m. for your invite.
Yes, I blame, you were my number one suspect, but now we've got number two suspect. Here, all right, we're gonna resume our arraignments. We were about 3/4 of the way through them. We took a break to check in with the prosecutor. Davis is here with Miss Stoll. All right. We've taken a recess. Mr. Stickley, the public defender, has checked with the prosecutor's office on a couple of our no insurance cases. And if you watch us, you know we do this almost every day. We're going to return to the matter of Christy Ann Keene. Ms. Keene, would you come up to the podium? The file number is 25892SM, Christy Keene. Ms. Keene provided proof to Mr. Stickley that she has current insurance at Progressive. In fact, if she's accurate, she actually had it the day of the stop, but didn't have proof with her in the car. So Prosecutor Davis has agreed to reduce this to a charge of no proof of insurance. That's the civil infraction I told you about. It's not a crime. It's punishable by a fine only, and the fine is $150. You understand?
Yes, sir.
And are you willing to admit to that?
Yes, sir. I was in a bad location and my phone wasn't coming, like service was bad, so I couldn't pull up the proof of insurance.
All right. Fine and cost is $150 and it's due within 30 days. We'll make it due within 29 days, which will be July 11th. Can you pay that by July 11th?
Yes, sir.
Well, if you need more time, you can start to pay in payments, but the civil infractions by operation are set within 30 days. 150, it's certainly better than 325. So the misdemeanor charge is dismissed. You have valid insurance. You can pay on credit card, green cash, certified check, or money order. And Ms. King, you're good to go on about your business. Thank you for your patience.
Thank you.
Chantel Goodman. All right, good morning. Ms. Goodman, you're in the same boat as Ms. Keene. You now have valid insurance through State Farm. Mr. Stickley shared that information with the prosecutor. And same thing, she's willing to reduce this to a charge of no proof of insurance, the civil infraction. Are you willing to admit to that charge?
Yes.
All right, anybody threaten you to get you to do that?
No, sir.
All right, can you pay the $150 within 29 days?
Yes.
This doesn't go on your driving record, I don't believe, as a moving violation or anything. It doesn't carry any points. It's a civil infraction like running a stop sign or something. But just pay that within 30 days and this matter will be completed.
Thank you.
You're good to go. Again, thank you for your patience. Ms. Boshev, your case is a little more complicated. Come on up to the podium. You're charged with no insurance, the same as the last two defendants, and improper registration plate. You haven't restored the insurance or the plate, so the prosecutor has a different plea offer in your matter. Ms. Davis, if I understand it here, the offer is to plead to allowing another to violate the motor vehicle code and dismiss the other charges.
Yes, Your Honor.
It's an interesting plea offer. It is a generous one. They're going to dismiss the no in plates, which is to save you $120. And they're going to dismiss the no insurance, which is going to reduce your fine by several $100s. But the misdemeanor charge of allowing another to violate the motor vehicle code is the plea offer. The others were a civil infraction. This is a misdemeanor, a very minor one. It's punishable by up to 90 days in jail and a fine of up to $100. It carries no points and it doesn't go abstracted on your driver's license. Do you understand?
So it's just like a fine that I would have to pay?
Yes, I'm going to give you a fine. I'll give you some time to pay it.
Okay.
Other than that, did anyone promise you anything?
No.
Or threaten you?
No.
And as you told me, you were driving to school to pick up your daughter or
It
drop
was
her off?
later in the afternoon. My neighbor's daughter was babysitting my youngest and they had went on a walk when it was still sunlight out and walked up to her mom's work. And her mom didn't want them walking back on the highway at nighttime.
Well,
And
you
I
weren't driving
didn't
to
really
school.
want her
This was
walking with my
10:43
2-year-old.
at night.
Huh?
This was 10:43 at night.
Yeah.
This doesn't have anything to do with school. I'm sorry. 131 of Dickinson Road. Where were you going?
I live in the trailer park in Constantine.
Yes.
I just got back with my grandparents from dropping off my 2 oldest in Three Rivers. And then he left and I was taking a shower before I went over to my neighbor's to grab my youngest. And when I went over there, she wasn't there. They had apparently went on a walk and they didn't want to come back on the highway alone. I didn't want them coming back on the highway alone that late.
How long's your youngest?
So-
Youngest?
My youngest is 2 years old. They're walking around at 10 o'clock at night with a No, I 2-year-old? have a big wagon. It's like a stroller wagon. So they put that up. It's got a big canopy on it and
Where did they walk to?
McDonald's right there in White Pigeon. That's where her mom works.
They walk from the trailer park to White Pigeon?
Yeah.
You need a new babysitter.
She goes on walks a lot. I have 2 big dogs. They have 2 big dogs, and she'll come over and just take my dogs on walks all the time. Sometimes my daughter will trail along with her if they're going like down the trails in the woods. But they like to hike, so she gets it from her mom.
Well, I'm not gonna even go down that road. All right. Plus, you told me you were going to pick your daughter up at school. This is all pretty bogus. Your license is.
I wasn't saying I was picking her up from school. I was just saying that from what I understood on the restricted license, I was still able to pick my kids up. And I thought it said like kids up from daycare, from school, stuff like that.
No, you can't. You can't pick your kids up from daycare or school. Let me go through it again. So that's outside of your restrictions. May drive to and from your residence and place of employment, treatment, support group meetings, regularly scheduled treatment for medical conditions, probation, community service, and your school must carry proof of destination and hours. Shall not drive a vehicle requiring a commercial driver's license. This is a very generous offer, and you should be grateful to the prosecutor for it. It's a $100 fine, $125 of state costs for a total of $225. Now, paying the fine will give you less money to reinstate your car insurance, but can you pay that within 30 days?
I should be able to, or at least start with making payments, get something set up with them. So I should be able to pay it all off by then.
All right. Who brought you here today?
I drove here.
That's outside your restrictions also, but I guess it's court. But that's not within your restrictions either. So drive home and stay home.
Okay.
Don't let your kids go walk around at 10:30 at night in the dark. That's all spooky on a school night. All right. You're good to go.
Thank you.
All right, Mr. Wilson's going to take a little bit to unpack here. Antonio Wilson, would you come up? Laura, would you bring me the pretrial? Do you have the pretrial files on Mr. Wilson?
We do have.
All right. Can I see those? Mr. Wilson is set for arraignment today, and he's set for some pretrials today. Prosecutor Davis is here with their internist Stoll, and we'll see if we can sort all this out. Two 5-101. I don't want to start with that one. 25807 and 808. He got a ticket on April 30th for driving without insurance and no valid operator's license, and failed to yield to an emergency vehicle. you had a pretrial, or you had a case earlier, you didn't show up. So I tried to reset everything for the same day. So that was on April 30th. Let me look at that ticket. M60 and Fulton Road in Leonidas at 10:15 in the morning on April 30th, which was a Wednesday. No insurance, driving without a license, and failing to yield to an emergency vehicle. The insurance, as you heard, is a misdemeanor, punishable by up to a year in jail and a fine of up to $500, not less than $200. Then you got another ticket in file 251017. On June 2nd at 11:15 at night, US 131 and Broadway. Driving at 2008 out. So that was set for one day, I don't know what. So that's a no operator's license, is a misdemeanor, punishable by up to 90 days in jail and a fine of up to $100. Let's go back a little farther. You got a ticket on April 7th for driving with no insurance, no valid license, and going 95 in a 55-mile-per-hour zone. So you got a ticket on April 7th for driving without a valid license, no insurance, and driving back to the future. 3 days later, you get the exact same ticket, 23 days later. No insurance, no ops, failed to yield for an emergency vehicle. Plus there's some civil infraction stuff in there. Then, you still don't care, on June 2nd, you drive some more and get another no ops ticket, and you drove to court. There is jail in your future, Mr. Wilson. My suggestion is that I get an attorney to help you with this and set this for further pretrial. Ms. Davis, there's a lot going on here. You're probably not in a position to make a plea offer that would resolve all of these at this time.
No, Your Honor. I guess if the court and Mr. Stickley to inquire as to work, that sort of thing, I'm inclined to ask for the court to take him into custody and start serving time now. It's frustrating.
It is frustrating, and I've done it.
And 95 miles an hour, I looked up where that ticket was. It was Lutz and Woodside, which is near Sauganash Golf Course. That is a very dangerous area that goes up and down, and there's the railroad tracks there. It is absurd that he would be driving that fast down Lutz Road.
Yes, the problem is I didn't see him drive. The bailiffs did, and he's not charged with anything. At one time, I was lodging people for these. I'm not sure I actually had authority to do that. He doesn't seem to be taking things very seriously. Yeah. But I think he could. So now you've come to the attention of the head prosecutor. So she knows who you are. She knows what you're doing, and they're going to pay attention to this case and probably advocate for a jail sentence because you don't seem to be taking things very seriously. Are you working somewhere?
Yeah.
Where do you work?
Well, I start work Monday.
Where's that?
The gas station.
Which one?
It's like out there by Jones.
I'm not sure I even believe that, but you live on A.L. Jones Road. Is that true?
Mm-hmm.
All right, I don't know what you were doing in Leonidas and Three Rivers and the other driving so fast. I'm not, I bet if I called Johnny's gas station, they would say they didn't know who you were,
But
but
Lightning Quick, which I think is the one that would be just east of that. North side of
the other, the little one?
that.
Okay. All right. Anyway, I'm gonna appoint an attorney. Show a plea not guilty.
You can make arrangements to have somebody pick them up, Your Honor.
Yes. Appoint an attorney and set attorney pretrial for July 11. We're gonna be very busy that day. Give you a heads up, Deborah. So if you want the prosecutor to get what they want, you drive home from here and you'll get picked up on the way there and they'll impound your car and take you to jail. You need to start to take this seriously. You've hit rock bottom and continue to dig deeper still. Let's talk about your driving record and why you're in the position you're in. Your license is expired. Gee whiz. So you were actually eligible to get your license back. And then you keep doing this. Did you ever go to SOS to get your license back?
No, I only got as far as a permit.
Well, I would suggest that you go to the Secretary of State, find out what you need to do to get your license. There really isn't that much baggage on here, but you're heaping it on here. I don't know why in the world you'd be going 95 miles an hour in that location.
Passing a vehicle.
Yeah, at the time I was passing two vehicles.
Oh boy, that makes it even worse. It's not straight and flat. It's straight. If you look at it on a map.
I wasn't by the golf course spot.
All right. Well, you're by Woodside Drive, which is still very hilly south of there. At any rate, stop doing what you're doing before you get so deep in the hole you can't get out. So 3 suggestions. I want you to go out to the counter and they'll give you the paperwork regarding your attorney's name and number on it. You got 3 separate incidents of driving with no insurance and no license. April 7th, April 30th, and June 2nd. And today is June 12th, and you drove here to court. Who owns this Audi?
Me.
I will park it till you get licensed and insured.
Oh, I have insurance now on it.
How do you get insurance without a license?
My mom's.
All right. That might help. So I want you to go to the Secretary of State. You need to make an appointment. You can do it online, go in there and talk to them. Say, what do I need to do to renew my driver's license? Then I want you to call your lawyer and make an appointment to discuss this case with them prior to July 11th. And I want you also to show your lawyer that you have current insurance on the car. And then I want you to call somebody to come get you, or your car is going to get impounded and you're going to go to jail, and then it's really going to be even worse. So even though I wouldn't mind locking you up, I don't know that I have the authority to do that because I didn't see you do anything. But don't do it. So you go out to the counter, get the paperwork with your lawyer's name and number on it. I want you to call them and discuss this. I want you to make an appointment with the Secretary of State to find out about getting your valid license. All right, you're good to go. And then call somebody to come get you. This also goes with that. Okay, you're good to go.
All right, thank you.
I think that finishes everything we had for this morning. Deborah, I understand we're stacking up for jail arraignments this afternoon. I'm going to try to do them at 2 o'clock if you're interested. I have Wesley Halsey Jr., Arno causing injury, larceny of building. Travis Elkins, Arno possession of meth, MDOP. Dakota Bruce, I'm not sure what that is. And she gave me a couple more. Jay Krantz and Shannon James, or James Shannon. So
Well,
looks like we have at least 5.
Are all of those in custodies, like from
They're all in
not, they're brand new in custodies? So
Yeah.
Josh, I'm sure, has been over in Three Rivers working diligently on them.
So apparently, yes. Some are old warrants.
Okay.
This James Shannon's at 24. Anyway, we'll take a shot at all that stuff at 2 o'clock.
Thank you, Your Honor.
All right, thank you. Mr. Stickler, thank you for your help. Oh, let's talk about our no-shows while we're here. Nathaniel Charles Lusk. Seems like he's got other problems. Larceny over 200, less than 1,000, and disorderly person. He had an arraignment on the disorderly person. The other charge, he's previously failed to appear. Got arrested on June 2nd. Let's make sure he's not in jail. No. He's not in our jail. 242187 SM is a larceny over 200 that he missed several previous arraignment dates. He got arrested on a bench warrant on June 2nd, posted bond, and promptly failed to appear again. He got charged also with a disorderly person. He was supposed to be here yesterday on the disorderly charge and today on the larceny charge. Well, he didn't show up either day. The disorderly person charge got authorized on January 9th. It's an ordinance case. He failed to appear on June 11th or June 12th. Do a bench warrant. And 242187 SM. I'm going to return it to $2,000 cash or surety. No 48-hour hold. On the disorderly, to bench warrant, bond, $250 cash or surety, no 48-hour hold. I think he's failed to appear December 30th, January 23rd, bonded out of jail on June 2nd, failed to appear. This is the 3rd time he's failed to appear. So if anybody knows Nathaniel Charles Lusk, please get in here. He has multiple open warrants for his arrest. Then we have Daniel Kuipers of Jones, driving suspended second, and no proof of registration. And no insurance. He just got the ticket. We'll do an order to show cause in those files first. Thank you, Mr. Stickley. I'll see you at 2. See how many more cases Shana puts in for us at that point.
All right.
Probably up to a dozen by then. There's no phone number for Mr. Kuipers. He lives on Bear Lake Street in Jones. There's an order to show cause. Take another attempt to get him in here. All right, that finishes our morning docket. I think everybody that was supposed to be here was here, except those last 2 guys. There were some pre-trials that Ms. Davis had. I don't know what happened to those. All right, take a recess. All right, we'll stop the live feed. Got some work to do for the meeting at noon. We'll be back at 2. All right, good morning. We're back. Matt.